Thank you very much, Miss Susma, my Lord, Honorable the Chief Justice, High Court of Sikkim and Patron-in-Chief, Sikkim Judicial Academy, Honorable Mr. Justice Bhaskaras Pradhan, DGP Sir Sri Akshay Sachdeva, a big congratulations to you on being the DGP recently, IGPs, additional DGPs, other senior ranking officers, my judicial brethren, judicial officers, other officers from the High Court Registry, everyone. I would like to first of all thank my Lord for providing me with this opportunity to be one of the speakers in this very unique program, I would say, maybe first of its kind, and also for providing this platform as an interface for the two main criminal justice functionaries. Well, the topic assigned to me, you can see it on the screen, is of the many topics I have been assigned the first one, an overview on the laws regarding arrests. As you all know, we all are experts here, very high-ranking top brasses of police, Honorable Justices, Honorable Chief Justice himself is here, senior judicial officers are here, but I don't see the newly recruited judicial officers, judicial magistrates. The law clerk is also here. Well, we know what arrest is. We know when one would be a person accused of an offense, whether wrongly or rightly, would be deemed to be arrested. There could be physical use of force, or it could be symbolic as well. It's one of the, I would say, after the criminal law is set into motion by lodgement of the FIR or a complaint, is the main action, I would say, on the part of the police authorities, where the accused, as I said, whether rightly or wrongly accused, comes into contact with the criminal justice system. Now, before I delve on the integrities and legalities of the arresting procedure, I just wanted to, just to set the tone and the momentum for today, I just wanted to take you through some videos, not from our country. I wanted to play safe, so I retrieved few videos from the most developed country in the world, just to show how the police in that so-called most developed country in the world treats the accused persons. Well, I will request my man Friday for today, Mr. Sagar of our computer cell, to play the first video. And these are very short videos, and with my Lord's permission, I would like to play all the videos so that I can give you an idea of the situation, especially for the judicial officers, the idea as to how an accused, a prospective accused, would actually come into contact with the criminal justice system. So, Mr. Sagar, the first video, please. The visuals might be disturbing, but no one is faint-hearted here.
In Minneapolis, released the body cam video police wore the night that George Floyd was killed. That video comes from body cam worn by former Minneapolis police officers Thomas Lane and J. Alexander Quang. This is the first time, folks, that the public can see what happened through those body cameras. Now, we should tell you that the video is in fact disturbing, no way around that, and we have made it a point to not show you the full graphic content for the purpose of this report. The 30-minute video shows officers at the location. The store clerk says he received a fake $20 bill from a gentleman in the car. Officers find Floyd and another man in a vehicle. The body cam video shows the moment of his arrest.
Let me see my hand. Put your hand up there. Hands on the wheel.
Police officers handcuff Floyd and walk him to the squad car. The cops then try to get him inside the vehicle. And that's when Floyd resists, saying he's claustrophobic.
I'm not the kind of guy who's I'm just claustrophobic. That's it. Well, you're still going in the car.
He also says he's had COVID.
Okay, I had a couple water drops because that was my heart. Oh, roll the windows down, man. I'm not the kind of guy. I'm not that kind of guy, man. Take a seat. Yo, I'm gonna die here. I'm gonna die, man. You need to take a seat right now.
The cops push him in, but Floyd, still handcuffed, is able to get out from an open door on the other side. The cops bring him out of the car and put him on the ground. On the ground, Officer Derek Chauvin puts his knee on his neck. A few minutes later, Floyd stops talking. At some point, the people start arguing with the police officers to get off of him. A few minutes later, Floyd's body lies still. The paramedics arrive. Officer Thomas Lane gets into the ambulance with Floyd on the gurney and offers CPR. Eventually, Floyd is put on a chest compression device as paramedics work on him. The body cam of Officer Alex Quang shows him going back to the store to collect the $20 bill that's all.
You saw that 20? What did you purchase with it? Cigarettes.
Well, a coalition of media companies asked for that video to be made public. Hennepin County judge overseeing the case ruled Friday to make the video public. That's why we were able to share it with you. Now, folks, if you care to watch the entirety of that video on your own, you can do so and find it on our website, cbsdfw.com.
Though we have 4 other videos, I would request Mr. Sagar to play only one video. You've got the idea now. Any of the other videos. Khali hoda.
Welcome back. 2 South Florida officers are charged after a rough arrest caught on camera.
Surveillance video showing one of the officers punching a man who was already in handcuffs. Let's get back to local news reporter Glenna Milberg live now where this happened. Glenna.
Now the Lori right here at this house. Last March, you'll see there's video cameras all up the block. This is on surveillance. And the police department, a group of them were here to good police work. And then there was some bad judgment. And then there was an attempt at a cover-up.
You see it there, right?
This is the evidence in a cover-up. An officer accused of spiriting away what he thinks is incriminating video images and equipment in a pillowcase.
A way to tamper with evidence that would completely indict an officer from using excessive force.
But let's start at the beginning. Last March, when a team of Miami-Dade officers raided this home in Allapattah to arrest people dealing in stolen airbags. But watch what happens. The sergeant suddenly delivers a left hook to the 18-year-old in handcuffs. And for that, veteran Sergeant Manuel Reguero is with misdemeanor battery.
Dealt with a spit, but I don't know why he did it.
Worse than a crime? A cover-up. According to the arrest affidavit, that team, Brian Crespo in handcuffs.
Well, we have some idea. I've just set the tone for today's program. Now imagine in the most developed country where the police officers hold body cams, if this is the way they treat the accused, and you know in the first slide was none other than late Floyd. Imagine in a country like ours, a vast country with places which literally cannot be controlled, with no body cams, what would be the situation? So please don't quote me anyway, but I think barring few states like ours, situation is still, I would say, grim and the somber situation, you all know that. Well, after that, now that is the point of contact between the accused and the police officers. Now that the interlude, that period between arrest and till he is brought to the magistrate's court, produced before the magistrate, I just want you to go through one slide. The next slide. Yes, I'll just read it out and then I'll have a question for you. In the afternoon, I was removed to the central jail in Kannanur and caged in a cell. I was all by myself. Iron bars and stone walls talked to me mutely. A warden would occasionally pass that way. There was no latrine with a sense of privacy, and one had to make do with the available facilities. In the loneliness of the prison cell, time stood still. The minutes would not move, and the hours slept with no duty to perform. The jail food, what all that I had, the days, once in a long while, were punctuated by brief interviews, once a week with close relatives. A low wall separated us, and a warden stood here as if some dangerous secret would be communicated. I had some plain paper with me and a pencil. I was drawing a rough blueprint of the house. I had planned to build on a lovely plot I had bought before the police nabbed me. I had planned to build on a lovely plot I had bought before the police nabbed me. Somehow, the jail staff misconceived my rough draft in pencil as a plan to escape, and so the paper was taken away. During daytime and night, plenty of bugs sprayed under the bed and sucked the blood, and at night, on top of the bug menace, came the mosquitoes winging, singing and stinging. So sleep was a feat, and this ordeal went on for days. Can anyone guess who could have mentioned this in his memoir or his autobiography? Can anyone guess? Especially the younger lords. We'll play the next slide. Well, you may recognize the much younger gentleman on your left, but the legend, he is none other than Justice V.R. Krishna Iyer, the late Justice V.R. Krishna Iyer, and probably I may be the only one in this room, subject to or exceptions like Honorable Chief Justice and Justice Bhaskar, who has actually met him in flesh and blood. It was none other than Justice V.R. Krishna Iyer himself, who had been incarcerated in that particular hazat, as you call it, that particular cell in a small police station in one of those remote places in the state of Kerala at that point of time, because of his sympathizing with with some of the communist workers, party workers. Anyways, now you know, not only at the time of arrest, but also while in custody, be it for an intermittent period or maybe after that, till bail is actually granted. These are the humiliations, these are the, I would say, the degrading treatment which an accused has to face. Well, I would request Mr. Sagar to go back to the first slide now. Now this is a quote, first page, yeah. This is a quote from none other than Arnes Kumar's case, which has been actually causing a lot of consternations to our police officials, to our police establishment, because they still have to use their brutal force, because that's the colonial hangover they have. Some of our police officials still think is the right way. Well, I'll just quote it, and since we'll be dealing with Arnes Kumar a lot of time today, I think this would also set this tone for the tone for them. Now, arrest brings humiliation, curtails freedom and casts scars forever. Lawmakers know it. It's so, also the police. There is a battle between the lawmakers and the police, and it seems that the police has not learned its lesson. This is as recently as in the year 2014. We are not talking about the police Raj period. The lesson implicit and embodied in CRPC. It has not come out of its colonial image despite 6 decades of independence. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by the courts, but has not yielded desired result. Power to arrest greatly contributes to its arrogance, so also the failure of magistracy to check it, our judicial officers, mainly for our judicial officers. Not only this, the power of arrest is one of the lucrative sources of police corruption, maybe in some places. And let me be absolutely clear, I am not talking in the context of our state. This is a general, whatever I would be saying, whatever I would be showing is for at general levels. The attitude to arrest first and then proceed with the rest is despicable. These are the words of the Honorable Supreme Court. It has become a handy tool to the police officers who lack sensitivity or act with oblique motive, unquote. Well, when we talk about Arnes Kumar, I'll straight away go to Arnes Kumar, because till Arnes Kumar came to be decided by the Honorable Summit Court, I don't think Section 41 of the CRPC, now I can say the previous CRPC, 1973 one, was not put into use. the checks and balances implicit in that particular provision was not put to use. It was given a complete go-by, but only after it was reverberated and asserted by the Honorable Supreme Court in the harshest of language that it has actually been being complied with by both the police officers as well as by the magistracy. Well, I think you can go to the judgment part. No, the other slide. The folder of judgments. I'll just take you through some of the main provisions. Well, till Mr. Sagar gets a hold of that. Well, we know the new CRPC, also known as BNSS. I actually have to look at the law, look at the book, to actually pronounce it properly. Bharatiya Nagrik Suraksha Sanhita 2023. Now we know it's more of a old wine in a new bottle, but someone somewhere has to show that they are working. Now some of the provisions can be found in, let's say, from section 35, 36 onwards. Mostly they have been reproduced and with some tweaking here and there. It's more or less the same provisions. I think section 41, Arnes Kumar dealt with 41, is now section 35 or 36. Now, Mr. Sagar may go through, Arnes Kumar, and go to the last page. And let me tell it clearly, I am not here to teach anyone anything. As the famous English writer Samuel Johnson would say, we need to be reminded more than we need to be taught. So I am not teaching you anything new. I am just reminding you. And this is why His Lordship Honorable the Chief Justice has provided us this platform. No. Alik Mati Janos, Mr. Sagar. Scroll up. Ajay Mati. Okay, yeah. Yes, para 11 onwards, and I don't see the new magistrates, Mr. Bhutia. Because this was supposed to be for them as well. Well, anyways. Well, coming back to Arnes Kumar. Now, this is the main portion of the judgment, the main dictum, the fiat of the judgment, which it seems is causing a lot of consternations to the police establishment, but at the same time is supposed to be the Bible, the Gita, the Quran for the judicial officers. Well, it says, our endeavor in this judgment is to ensure that police officers do not arrest the accused unnecessarily, and magistrate do not authorize detention casually and mechanically. In order to ensure what we have observed above, we give the following directions. All the state governments to instruct its police officers not to automatically arrest when a case under section 498A IPC is registered, but satisfy themselves about the necessity for arrest under the parameters laid down above following from section 41 CRPC. If you could kindly enlarge it a bit, Mr. Sagar. Alikati enlarge continuous. Yes. Now, state governments have already issued various directions. The DGP sir is here. In subsequent judgments, in a very recent judgment, it was reiterated that even SOP has to be framed for arresting accused person. Well, here, this next point says, next direction, all police officers be provided with a checklist containing specified subclauses under section 41 so and so. The police officers shall forward the checklist duly filled and furnish the reasons and materials which necessitate the arrest while forwarding / producing the accused before the magistrate for further detention. Now, I don't understand one thing. Being a judicial officer now for almost more than 2 decades now, this happens to be my 21st year as a judicial officer. I don't understand why would it cause any consternation to the police officer investigating the case. All they are supposed to do is prepare a checklist, and why would they even go for making an unnecessary arrest? Now this is where our colonial hangover thing comes into picture. We have known our police to be a brutal force. So until and unless they actually become physical with the accused, they may not feel that the law is taking its course. Now the checklist, if you go to section 41, in the same judgment, 41 has also been reproduced. Go Mati Janos. Section 41, as you all know by now. Further up. When police may arrest without warrant. Now it's the same thing has been reproduced in section 35 or 36. I tell you exactly the provision. In section 35 of the new BNSS 2023. Any police officer may, without an order from a magistrate and without a warrant, arrest any person against whom a reasonable so and so, you all know that. Now what is required to be done? Alikiti Mati Sarnos. The police officer is satisfied that such arrest is necessary to prevent such person from committing any further offence, or it doesn't say, it is not conjunctive, it's disjunctive, or for proper investigation of the offence, to prevent such person from making any inducement, threat or promise or to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the police officer. As unless such person is arrested, the presence in court whenever required cannot be ensured. Now these specific provisions, these salutary provisions, these mandatory provisions have now been incorporated in your checklist. Now if a person is arrested with, let's say, some contraband drugs, maybe under NDPS or our local, our generic law, SADA, Sikkim Anti-Drugs Act 2006. Now if he is arrested with the contraband drugs, I don't think, irrespective of the quantum of punishment that particular offence attracts, any magistrate would straight away proceed to grant bail. All that the police officers have to do is show a little application of mind. They can always say, look, this is required because the accused, of course, he is not the producer of the drugs. He is also not the wholesale dealer or retailer of the drugs. We need to investigate into the matter. We need to go to the source. So obviously we need this particular accused for proper investigation of the case. I don't understand why the investigating officers do not mention this. No magistrate is going to say, no. How can you say that is for proper investigation of the case? Well, this is the mantra that we would give you from this particular platform. It is required for the proper investigation of the case. His presence is required. Secondly, given the magnitude of the offence, there is every possibility of him trying to abuse his liberty if granted bail. His interim liberty if granted bail. Then let's say an offence where the accused is a Nepalese national. I have done, maybe the first judicial officer who has actually delivered, to my misfortune, delivered the first POCSO judgment in the state while I was in Namchi. The accused was a Nepalese national. Now let's say if tomorrow an offence is committed and you arrest an accused who happens to be a Nepalese national or a Bhutanese national, which is rare of course, or maybe from some state where execution of warrant later on or even summons may not be feasible. Now you can always mention in the checklist your officers in that particular rank who produce the accused before the magistrate can always say, look, there are chances of his abusing his liberty, fleeing from justice. Even that can be mentioned in the checklist. No magistrate is gonna try and act like Justice V.R. Krishna and give bail simply because it has been asked for. There will be judicial application of mind. Only that our police officers have to bear in mind the fine balance between the power to arrest and the need for exercising that power in a rational manner. Not in a straitjacket. There is no straitjacket formula. There cannot be one size fit all kind of thing while arresting one. And unfortunately in our small and beautiful state, arresting someone, first of all it comes very late. Secondly, arresting someone in this state has unfortunately become something of a trophy for our police establishment, especially in political cases. Who would know better, because probably most of the corruption cases were dealt with by me in the state when I was the district judge in most of the districts, almost all the districts. Now, these checklists are no difficult documents. They can be filled only that the police officers need to fill it properly and for genuine reasons. There cannot be an eyewash. Any intelligent judicial officer who is a magistrate would be able to make it out. No, this is not the ground. So bail would be granted. Now, shifting from our police officers to our magistrates. Please go to the last page again, last portion again, Mr. Sagar. Now for our magistrates, we have CJMs and JMs here. Yes. Okay, that's it. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize detention. Now so far, Honorable the Chief Justice has been seeking monthly reports from all the criminal courts in the state. We have been ensuring that all the criminal courts in the state are complying with not only the directions contained in Arnes Kumar, but also in Sidhart's case. You all know which Sidhart was a state of UP, and also in Bhim Singh's case. All these instructions, all these directions are being complied with. We are seeking reports from each and every court, criminal court of the state, and Honorable the Chief Justice has been personally looking into these reports. Now for our dear magistrates, well, Alikati Matijan, Mr. Sagar, this might again cause consternations for our magistrates now. Authorizing detention without recording reasons as aforesaid by the judicial magistrate concerned shall be liable for departmental action by the Honorable High Court. So even the magistrates, they need to be careful. You are not exercising some power, even for that matter, even police, though everyone says power to arrest. Let me tell you, dear participants, it's only a misnomer. It's not power to arrest, it's your function to arrest. That is the problem. The moment you say power, that hangover would come into play. So even for our learned magistrates, please be wary of all these things. Please be very careful. If a complaint comes to the Honorable High Court, our main authority himself is here. We will have no option but to take appropriate action as per these directions. These are binding on all of us. Now, this judgment only spoke about section 41. Mainly spoke about section 41 and its sub-provisions. Now I am not going to go threadbare through each and every subsection or section. Like I said, we need to be reminded more than to be taught. Now, this judgment later on in Rini Johar's case, Rini Johar you all know, the same directions were reverberated in that judgment as well. Later on in as recently as in 2025, in Vihan's case, the Honorable Supreme Court said that even for arrests under PMLA, another interesting field for our police officers, PMLA, which is being used, of course not in the state much, but in some of the states, PMLA is the most widely used law for booking someone. Rightly, wrongly, that is on the merits of the case. Now, even while arresting an accused under PMLA or any other law, you all know these provisions of the code and these directions have to be complied with, even while making arrests under those laws. Please be mindful of this as well. Now, the other thing, Article 22 of the Constitution. Well, some of us, we tend to forget. I remember long time back, maybe in 2005 or 6 or 7, there used to be arrest memos. And the column which provided whether the accused has been informed about his arrest would remain blank. Well, now let me tell you, and this is a weapon for the magistrates to set set right the wrong. If the grounds of arrest are not made known to the accused, you are entitled to grant them bail on that ground alone. So please be careful. The grounds for arrest should also be mentioned clearly. In some cases, I don't know what is the situation right now, but you won't believe even the copies of the FIR were not provided to the accused or the counsel for the accused so that they could apply for bail. Now, these are few things which I wanted you to know. And, well, Mr. Sagar, we can go back to the side. I might have missed something. I will not go through the other judgments. You know the provisions. Well, we have had enough of this picture. Well, these are now talking about powers and functions. Now, Benjamin Disraeli, I don't know how to pronounce it, but it's a noun, so we can pronounce it either ways. Statesman, and what else? Can anybody tell me from this side as to who Benjamin Disraeli was? He was also the Prime Minister of the United Kingdom. Now he said, and this has been quoted, I am not quoting it, this has been quoted by Honorable Supreme Court in Rini Jaw's case. Golden words, I repeat that all power is a trust, that we are accountable for its exercise, that from the people and for the people all springs and all must exist. We are not self-seekers here. We are not in a private office for our personal progression. We are here for these people. Whether accused rightly or wrongly, we cannot give the mandate of law go by. Next slide, Mr. Sagar, if there is left. Well, this is only later on, but the expressions here, this is of course at the stage of after conviction, when the Honorable Supreme Court was observing this was with regard to prisoners. But I'll just read it first, and then I'll try and pass through what it has said. Imagine the helpless condition of a prisoner. You can read it with under trial prisoner or even a convict who is lodged in a jail, who does not know to whom he can turn for help in order to vindicate his innocence or defend his constitutional or legal rights, or to protect himself against torture and ill treatment or oppression and harassment at the hands of his custodians. Now this fits equally for people who are arrested and have to be incarcerated even during the first 24 hours. Now imagine the plight of the accused persons, the humiliations, the berating of these accused persons. All this was playing in the minds of the Honorable Justices of the Supreme Court when Arnes Kumar's judgment was authored and written. So please be mindful, not only the police officers. Arrogance is something our Honorable Chief Justice always says. Ego and arrogance will eat no one else but eat you up. Well, the last slide, my dear Sagar, Now he has become one of my favorite staffers. Now, for our judicial officers, our office has not been bestowed upon us to have a good time. It is to serve the higher purpose. And I'll just quote it again from a very interesting book which very few would know. This particular quote, of course it doesn't say anything new, but I thought I'll just share it with you. This has been quoted from Mr. Arun Suri's book titled Anita Gets Bail, What Are Our Courts Doing? What Should We Do About Them? Unquote. Well, many would not know, it is a very less known fact that Mrs. Anita, obviously the spouse of Mr. Arun Suri, was supposed to be arrested in a case, and he has talked about the ordeals, and he's not someone. He is someone who actually matters. Now, even at that level, the ordeals, the troubles they had to face, the tribulations they had to face while getting into the rigmaroles of the legal system, the criminal justice system. While talking about that, he's actually observed this, and this is mainly for the judicial officers, and I quote it: today, the judiciary is among the few institutions, perhaps one of just 2 or 3, that still commands respect. It is one of the few from which the people at large still expect something, and it has many, many sterling achievements to its credit. First of all, such accountability as survives in public life does so only because of the judiciary and sections of the media, more accurately because of a few judges and a few journalists. We don't have anyone from the media here today, but especially for our judicial officers, judges at any level, be it constitutional, be it at the district or the lower courts. I think we are here for a better purpose. As I often say in a lighter vein, our birth in judicial cadre is pursuant to some divine plan. So let it not go waste. A little application of mind by you, a little, my Lord was yesterday mentioning that there are some people who take their jobs as being a 9 to 4 or 5:30 job. It was in some other context. But for judicial officers, you all know we are on duty for 24 hours, as is with the case of the police officers. So I won't take much time, because audiences, they tend to lose interest after the first 20 or maybe 15, 20 or 30 minutes. So with these words, I won't discuss any cases, because I've already touched upon all the cases mentioned. Drop the names of the main cases, be it Arnes Kumar, Rini Zohar, Sidhart, Vihan, and every day we get new judgments. With these words, let me again express my heartfelt gratitude to my Lord, the Honorable the Chief Justice and Patron-in-Chief of the Academy, for providing me with this opportunity. It had been quite a long time since I had actually faced an elite audience like this. So it actually took me some time to gather my bearings. Thank you very much, my Lord. Thank you everyone for a patient hearing. And before, I mean not yet done, before I leave the podium, I would request the SJ staffers, any of the staffers, and I would request with folded hands, I would request my Lord. Well, it was supposed to be for the 8 magistrates and 1 law clerk. If at all they come, after they come, Mr. Bhutia, there are some books authored by none other than the speaker right now, as back as in the maybe a decade back, only for young law graduates. I would request, not now, I would request later on through the MC here, for my Lord to distribute these books to the new JMs, and of course to the new law club, because I don't see anyone else from the institute, from the legal institute. So my Lord, I have already sought my Lord's permission, and my Lord has implicitly given me that permission to distribute those books through him. So, Miss Rita, that would be your responsibility. Thank you very much. Jai Hind.
The permission of the Honourable Chief Guest, Honourable the Chief Justice, High Court of Sikkim, I'd like to begin my discourse. It will be short, and perhaps you may find some interest in this particular discourse and this particular session. Since this is our academy, I'd like to welcome Mr. Sachdeva, the Director General of Police, the senior members of the Sikkim Police, the other officers, my worthy colleagues, the Registrar General of High Court, Director of the Judicial Academy, Registrar Judicial Service, Registrar, CPC, the learned CZMs, learned Judicial Magistrates, Mr. Rudra Vimal, the Joint Registrar, and everyone who are present here. Now, the topic that has been assigned to me is on bail jurisprudence. And you would all know that arrest, bail, remand, they go hand in hand. Once there is an arrest, there will be a remand. Can be and cannot be in some situations, and there could be an application for bail after arrest or before an arrest. It is said that the word bail comes from the French word I do not know how to pronounce, but it's something like blah blah blah. It's boula. I cannot pronounce it very well, but which means to deliver, to give. And the basic concept that I have, at least I could understand, is that a bail means a surety. To give a surety that in the course of your trial, in the course of the inquiry or investigation, you will make yourself available before the investigating officer, before the court, and before other authorities. If you see the Black Laws Dictionary, this is the definition of bail. The law lexicon will define bail as this, which essentially is a security that a person will be produced for trial or investigation. Now, you'd all know that the Code of Criminal Procedure of 1973 did not define bail. There were several judicial pronouncements which went to define or expound the term bail. And in the present BNSS of 2023, you'd find one definition in Section 2, Clause 1b, which is this, that it is a release of an accused upon some conditions imposed with or without a bail bond. So this is one of the, I think, a simple definition of bail. And you know that if you see the legal history of bail in India and across, you'd know that there has always been a conflict between the police powers, the exercise of their powers, and the liberty of a man. And in order to balance these two sides, the concept of bail has emerged. You'd also know that, like any other law, the law of bail is not static. It is ever evolving. It is growing day by day. And I will demonstrate with some of the leading cases of our country as to how the bail jurisprudence began and is still growing in our country. Now, you would also know that the concept of bail and the concept of liberty, they go hand in hand. And we can go back and see that in the Constitution of India, there is a particular article, Article 21, which guarantees freedom to life and personal liberty. Now, along with Article 21, there is Article 19, there is Article 20, and there is Article 22, which as a group we may call that it is right to freedom. And I think, and I'm sure that all of you will agree with me, that Article 21, or the right to life and personal liberty, is one of the most cherished rights. Because if you don't have freedom, then the other rights become meaningless. To go a little ahead with what my dear colleague, worthy colleague, Mr. Prajwal Khatiwada told us this morning about Justice Krishna here, quite some time ago, while I was reading his memoir, which, sir, you were talking about, like sir said, Honorable Justice Krishna here, late, before he became the Honorable Judge, he was an activist. And on several occasions he was arrested, detained, and he went to prison. In one of the letters that he wrote, we had seen that in the morning. And in that memoir, and in that autobiography, what Honorable Justice Krishna here writes is that one day in prison is like 100 days outside. Which means that if a person is bound, if a person's liberty is curtailed, then it becomes difficult, it becomes laborious. Now, even if you are in this room, you know that you are free to walk out anytime. You have that confidence in your mind that I have the liberty to walk out from this room and do my other work or go anywhere that I want to. But if you are kept in this room without knowing as to for how many days you are here, for what charges are you here, whether you will be able to go back home late in the evening, whether you may be able to have dinner with your family, I am sure there is nobody in this room who would not feel anxious. And that, I think, is the essence of what the Article 21 guarantees to everybody. And mind you, Article 21 does not say citizen. Article 21 says persons. It guarantees freedom of liberty to every person, be it citizen of our country or not. When I talk about the Constitution of India, I feel that I am talking to a mountain when the Honorable Chief Justice is in my presence, because His Lordship has authored several means I'm talking about hundreds of judgments in various high courts across the country on constitutional law, on the writs. And I'm sure my Lord has come across several cases and has decided not only on the other articles such as 14 but also on 21. So moving ahead, as I said, it is a balance. Now moving ahead, the provisions of bail, so far as the statutory law of India is concerned, we find it in the Code of Criminal Procedure 1973, the old act, and its equivalent is in the BNSS of 2023. The honorable magistrates here, they deal this day in and day out, and I'm sure the police officers here at the top brass, you may not be dealing right now, but you have done this in your early years of career, and there are still the officers who deal with this on a day-to-day basis. 436, which is an equivalent to 478 of the BNSS, is when a bail can be taken in a bailable offence. So if there is a bailable offence, the first thing to do is to release him on bail when he is ready and when he can give you a security. 436 goes by the concept bail is a right and detention is an exception. 436A, the other one is an equivalent of BNSS. I will, please bear with me. And this is how the maximum term of UTPs during the course of investigation they go through. And this particular slide, I have brought it from BNSS, the present act, the present code, so that we are in tandem with the present time. First time offenders, 1/3. I will not read for the sake of saving time. 437, when a bail can be taken in a non-bailable offence, and in most of the cases where the offence is less than 7 years, the application for bail is filed under 437, the old code, before the honorable magistrates, and they deal on a daily basis on an application under 437. Now, 3 considerations even otherwise: if a person is infirm, sick, a child, or a lady, a woman, even if they are facing any of an accusation of an offence punishable more than 7 years, even then they can be released on bail under the provision of 437. This is a little digression from the chronology of bail, but this is also one of the concept of bail that comes in after the trial of the case is over. Now, this is suspension of a sentence, and you release a prisoner or a convict on bail so that he can file an appeal before the higher forum or the appellate forum. Now, one of the cases that I'd like to discuss, not discuss but just bring it to your kind attention, is this particular case of Pema Chering Bhutia versus State of Sikkim. This was authored, this is an IA, of course, an application for bail that was filed under that provision, and this was authored by none other than Honorable Justice Bhaskarraj Pradhan, who was present with us this morning. And somewhere in 2021, His Lordship quoted Preetpal Singh's case and said that the concept of bail, so far as investigation and after trial is concerned, it stands in a different footing. The concept of a person being innocent before conviction is ingrained in 437, in 438, in 439 of the old code. But once a person is convicted by a trial court after a full trial, it becomes something different. What it means is that bail cannot be a matter of right. It's a conviction. In the conviction order, in the conviction sentence and the judgment, if you find that there is glaring inconsistency, yes, you may release the convict on bail. Though in this particular case, Pema Chering Bhutia, bail was granted for the person to prefer an appeal. But quite importantly, this case of Preetpal Singh was quoted, and I'm sure my worthy colleagues will find it helpful if we can keep this in mind when we deal with appellate or appeals. Now, this is another one. Now, this is quite an interesting section, which is 438, which is an equivalent for 82, known as anticipatory bail. Now, we all know here what is an anticipatory bail. An anticipatory bail is an application when a person files in anticipation of an arrest, in anticipation that I may be taken into custody for a particular case that has been registered, or it is going to register, or it is going to be registered in the course of time. The Honorable Supreme Court of India and even our Honorable High Courts have time and again laid down that when an anticipatory bail is taken for hearing, it has to be taken up, first of all, as quickly as possible. Now, there is even a even a mandate now in Satyendra Kumar Antil, where anticipatory bail has to be heard and completed within 6 weeks from filing, which is not a case here, at least in Sikkim, because here within 5 days or a week maximum, otherwise on the 2 days or so we complete the hearing of an anticipatory bail. The cases that we deal with under anticipatory bail, I will show it to you a little in the other slides, but just now I'm just giving you a concept of what are the provisions of bail under the CRPC. The other one and the most used provision before the session judges are 439, and these applications even come up before the Honorable High Court. That is, when bails or an application for bail are taken up for hearing, whenever the cases come under, for example, the punishment is up to life, death, more than 7 years. In other words, most of the cases which are not triable in the Magistrates Court, these type of cases, the application for bail are filed under 439. Let me again quote my friend here. I'm not trying to teach, but it is only a reminder of what is there. And moving forward, it was Justice Krishna Iyer himself in 1977 in the case of Balchand. He said that bail and not jail. And this is a concept from 1977 onwards. The courts throughout the country have been consistently following that bail is a rule and jail is an exception. But at the same time, as I said, there has to be a balance between the right to liberty of a person and at the same time the security of a society. Now, how should we balance these? We can find these in the later slides, particularly when I come to section 41 of the old code as to when an arrest is made and how it is to be made for a cognizable offence. Joginder Kumar is a celebrated case of 1994. A young man, perhaps 28 years, a law graduate, he was taken into custody. Not custody in the sense he was arrested, but he was called to the office of the senior superintendent of police then, Ghaziabad. if I have not mistaken. And he did not come home. So his brother, along with others, they went, they requested, but he could not be found there. And thereafter this matter went up to the courts, and it was found that he was taken by Senior Superintendent of Police Ghaziabad for the purpose of solving some other cases. But there was an apprehension on the minds of the family members that he may be beaten up, he may be tortured, and there could also be a threat that there was also an apprehension of threat that he may have been or would have been encountered by the enforcement agencies. And in this particular case, the laws laid down in 1994 and the guidelines that the Honorable Supreme Court said in this particular matter is that arrest should not be arbitrary. As and when required, yes, you arrest, but don't do it in a routine manner. At the same time, the magistrates are also duty bound not to give remands in a routine manner, but apply your mind in cases where, yes, remands are required, you have to, but not in a routine manner. And you would all understand that after this pronouncement, later there was an amendment to the Code of Criminal Procedure, and this particular section 41 that you see now is, in my humble opinion, what the Honorable Supreme Court said in Joginder Kumar, and that is the reason why I said that this is one of the celebrated matter so far as the bail jurisprudence in India is concerned. Sanjay Chandra is another matter of 2012, quite recent, where the Honorable Supreme Court has given a detailed or made a detailed observation as to why should a person be granted bail. And I'm sure most of you will remember this is a 2G spectrum matter. And it was said, the interesting phrase that I always remember of this particular case is that you should not keep somebody in custody just to give him a taste of punishment. Now what it means is that the philosophy that the Constitution of India, the courts throughout the country follow is that a person is innocent until proven guilty after a trial. Pre-trial arrest and pre-trial detention just to give him a taste of punishment should be avoided. This is one matter. Gurbaksh Singh, Sibia. This is of 1980 matter. This, as I said earlier, I would deal with some of the cases on anticipatory bail. Sanjay Chandra as well as Gurbaksh's case is on anticipatory bail, where some of the conditions had been laid down by the Honorable Supreme Court, and it was said, interestingly, that FIR is not a precedent. It is not a condition precedent for hearing and granting a bail under 482. There need not be an FIR registered, but if there is a reasonable apprehension in the mind of that person that he is going to be arrested, then the courts are to exercise the power granted under 482. At the same time, keeping the balance, it will not affect the powers of the police to conduct investigation. Once a bail is granted, anticipatory bail, it does not fetter the powers of the police to conduct fair, impartial, and proper investigation. I will not read all this, but these are the provisions that were laid down in this particular case. This is another famous case of Sitalangappa Maitri of 2010, where some of the guidelines have been culled out is that whenever you sit, the honorable judges, to decide a matter concerning bail applications, gravity of the offence has to be considered. The role of the accused, his antecedent, possibility that he may flee from justice, he may run away, and likelihood that he would be involved in similar offences. These are some of the guidelines that were given in this particular case. Now, let me come to Arnes Kumar and then to Satyendra Kumar Antil's case, which I think is causing quite a confusion amongst all of us here. Now, in order to understand Arnes Kumar, what we are required to properly understand is 41. My colleague here has already given you the picture of what 41A is. I will not deal with it much, but you have to remember that 41, which is I think equivalent to 35 in the current BNSS, these are the requirements that you have to keep in mind whenever you need to arrest, so far as those offences which are punishable less than 7 years. If it is punishable with more than 7 years, Arnes Kumar does not bar you, but if it is less than 7 years, you will have to see 41. And 41 particularly, I'll come to the next slide, B. 41 clause 1B, you have to keep this in mind that there is a reasonable suspicion he has committed a cognizable offence. With this and the following are satisfied. You have reason to believe that he has committed the said offence. You are satisfied that his arrest is necessary. Particularly this clause 2 is, I think, very, very important. You may not note it down, but please remember that clause 2 of this particular section 41 is very, very crucial if you want to arrest, if you want to take a person into custody, and if you come before a magistrate, the learned magistrates will keep this provision in mind before allowing or not allowing an application for remand. Now, if you satisfy that yes, under these provisions we have made out a case, I am sure there is no magistrate here who will not allow remand. Because as I have said, these two are the balancing acts which we have to follow. If you don't allow arrest at all, if you don't allow remand at all, then what happens is that the antisocial activities in the society may increase. And that is also one factor which the law do not permit. And at the same time, like I said, the right to life and personal liberty of a person has to be kept in mind, so that a person who is innocent, a person who is taken into custody just because he is poor, should not be a factor for taking the remand. And that is the reason why the honorable magistrates here are circumspect. They check the remand applications thoroughly before the applications are either granted or not. So these are the necessary conditions. You want a remand, you want to arrest because you want to prevent that person from committing further offence. You want a proper investigation to be done, or you want to prevent causing of disappearance of evidence or tampering with evidence. You want to prevent that person from making an inducement, threat or promise to the victim or to the witnesses in that particular case, or that the presence cannot be ensured. Now, if you feel that the arrest is not required, you have to give your reasons in writing. If you feel that his arrest is required, then also you have to give your reasons in writing. Now a situation arises here, so far as Arnes Kumar is concerned, as to why at times the application for remand is rejected. Now the police authorities here you have to bear in mind that your checklist, which is a mandate now, the checklist has to contain these provisions. And for the sake of repetition, I will tell you that it starts from clause 2. You will have to give these reasons. In your checklist, it has to be there, number A, prevent that person from committing further offense. Tick, yes or no. Give your reasons why. You want proper investigation, yes or no. Why yes? Why no? If you want a proper investigation, give your reasons. The learned magistrates will allow the remand if these conditions are met. Because every person, every authority has to follow the mandate of law, since nobody is above the law. Now, what happens if you don't want to arrest? There are cases where the punishment is less than 7 years. Arrest is not required at all. And I will tell you that there could be 90% of the cases where arrest is not required at all. But at the same time, there would be 10%, sometimes more, sometimes less, number of cases where the arrest is required. Now, let me give you an example. A person is arrested for commission of theft. Now, for the purpose of proper investigation, what you require is that the investigating officer has seen the CCTV footage of that area, identified the person properly in the CCTV, want his interrogation, you want to question him. How did you do it? Is there anybody else involved? Where is that particular property that you stole from this house? Because you want recovery. Now, if there is no recovery, then your case is almost like FRT. You file a final report. There is no charge sheet at all. And what happens is that the aggrieved, the person whose property is stolen, the victim, in other cases, they come to the police stations again and again and ask, what has happened? Why not? CCTV is clear. You can see him here. So why can't you question him? But if your checklist does not mention anything, then there will be no remand. But if you want this, you will have to give a proper checklist. And that is the reason in these type of cases, my humble opinion is that interrogation is required. You need to sometimes take that person into custody and ask him, because there would be recovery of these kind of theft matters, and at times he may have sold it off, sometimes to a person who is a regular dealer in these kind of matters, and sometimes to an innocent person. Now, under 41A, you give a notice that you have to appear before the police station on a particular date and time. You follow that, arrest is not required. But at the same time, after you have issued notice, In the course of your questioning, if the police officer feels that, no, I have to take him into custody for some or the other reason, for a valid reason, not from some other extraneous consideration, but for a valid reason, and if the conditions laid down under 41, that particular clause 2 that I have talked about, is fulfilled, then you can also arrest him. But record your reasons. This is what 41A says. And you have an equivalent now in DNSS. Alright? Now what I'm trying to do is trying to give you an overview of Arnes Kumar, keeping in mind 41 and 41A, because these are very, very important so far as the investigating agencies as well as magistrates, whenever there is arrest and bail are concerned. Now, this is what the Honorable Supreme Court has said, and I fully agree. You have to ask to yourself, why is the arrest required? Is it necessary? What purpose will it be served? And what object you will achieve? Now, if you can answer these to yourselves, then yes, go ahead, arrest, satisfy yourself. But if you feel, when you ask these questions to yourself, he may be required or he may not even be required, now what do you do in such cases? In the courts we say we give a benefit of doubt. We don't arrest that person. Because once a person is arrested, taken into custody, there is a lot of complication. In the society, his reputation goes down the drain. People may feel that even if he is innocent, that he is a guilty person. Because we are living in a time when information passes in microseconds. We are living in a time of social media where the news, not good news, but bad news, travels like lightning. And like the other day when I was discussing with my colleagues, one of my colleagues mentioned that just an allegation of POCSO Act is sufficient for that person. You get arrested, taken into custody, sent to jail. It means at times it may be that person may be innocent. So these questions are very, very important. Let me give you an example. I will not tell you which case, but just yesterday, in the course of my judicial work, one matter came up in the bot, and that matter was for malicious prosecution. I will not say who, but a person was arrested, taken into custody, later released on bail, and at the end of the day, after investigation, the complicity of that person was not found at all. Therefore, a final report was filed, and the person said that for wrongful arrest, for harassment, for my reputation in the society to have been marred, and the agony that I have undergone, I require compensation. Now the matter is still pending, but what I am saying is that if there is an unjust arrest, these kind of matters will come to the court. And that is the reason I think we should all keep in mind, so far as the investigating agencies are concerned, as to why do you need an arrest? You satisfy yourself, take the remand. Now, these are the certain directions which my learned colleague has already gone through. I will not deal with this once again, but like I said, 41 clause 1b sub clause 2 is very, very important, because your checklist has to be in accordance with that. If you have not made, I am told that checklist is already ready so far as Sikkim police is concerned, but in many matters, I am tell you frankly, though I don't deal with remand matters, but at times it comes on revision, and I see that either there is no checklist or the checklist is defective, because it does not follow this provision. Arnes Kumar says that do it. Take 41, clause 1, subsection 1, clause B, subclause 2. These conditions, you mention it. Put a box, tick, wrong, reasons. But what we have done is, I see that the investigating officers, I'm sorry to say, but in the courts when it comes, the learned magistrates see, and then there is no checklist, or the checklist does not contain the provisions. So this is, I think, one forum where we can discuss these issues, and we can sort it out. Because what I believe is that there has to be a balance. The investigating agencies are also working for the benefit of the society, and at the same time, what we do is we work for the people of this country. These are the mandate, which I will not read so that we can save some time. Failure to comply, that would be dereliction of duties. And Satyendra Kumar until, which is a recent one, there are a series of directions, but this particular order of 11th July 2022 gives the direction as to how bails are to be taken up, as to how arrest is to be made, and as to how arrest should not be made, and as to how the authorities, the state government as well as the Honorable High Court should take up this matter. Now, interestingly, what it says is that in this guideline also it says, one of the guidelines is follow Arnes Kumar in letter and spirit. What it means is that the guidelines of Arnes Kumar, which you have just seen, has to be followed. This is the second case where the Honorable Supreme Court is saying, follow Arnes Kumar. Investigating agencies are duty bound to comply the mandate under 41 and 41A and the directions issued in Arnes Kumar. Dereliction again gives these directions. There has to also be a strict compliance so far as the judgment of Sidhart is concerned. Now, Sidhart judgment, I'll take maybe, Lordship, if you allow me 5 minutes time. So far as Sidhart is concerned, there is a provision under 170 of the CRPC that when your evidence is ready, your investigation is over, what you do is you forward the accused along with the proof or along with the materials to a magistrate. Now, this particular matter was sent to a magistrate. Here is a special judge, where the special judge said, no, I'm not going to take this matter at all because there is no arrest of this person. Why have you not arrested at all? Now, when the matter came up before the Honorable Supreme Court, again relying in some of the judgment of the Honorable Delhi High Court, said, under 170, you should not misread that there has to be an arrest. Even without arrest, or even sometimes where the presence of the accused is not required, you have the material, the investigating agency's charge sheet should not be rejected by the magistrates. Because what happens is, there is a timeline for the investigating agency to file their charge sheet. Otherwise 167 comes into play. And even sometimes there is limitation. So the courts have been asked to follow Sidhart and not to allow or not to disallow the filing of the charge sheet at times even when the accused is not arrested. Now these are the other guidelines where the high courts as well as the state governments are to take up the matters. And also there is a direction to the Honorable High Court which we are doing as the District Legal Services Authority. My secretary, Ms. Rohini, is here, and some of the members are also here, the Senior Superintendent of Police, the District Collector. We sit and we sometimes deal with these matters where a person is not able to furnish bond under 440 of the Code, and where the applications are filed before the concerned court to reconsider as to whether bond can be reduced or it can be done away with and be released on personal bond as well. So this is just one of the other matter which came up before the Honorable Supreme Court itself in 2023, where again it has reiterated that Arnes Kumar has to be followed. Now there are two cases that I have already cited where Arnes Kumar is to be followed. 4141A is a mandate. Since the investigating agency have to deal with this, you will have to please keep this in your mind. Even in this particular case, the DGPs are instructed, even the Honorable High Courts are instructed to give guidelines. And last but not the least, this is other matter of 2023, where after the bail is given, sometimes the bail order does not go to the jail at all. So this is a case where the Honorable Supreme Court again passed a series of guidelines where soft copy is to be now sent to the jail. The NIC is to facilitate the software of e-prison so as the prisoner's details are interlinked, and whenever there is a bail order passed, it automatically goes to the court, and within 7 days, if that person is not released, an email automatically goes to the District Legal Services Authority Secretary, who takes up this matter in the DLSA by sending PLVs or the remand lawyers to the jail and finding out why he is not able to furnish security. And if he is not able to furnish security because of the reason that he is poor, because of economic factors, then an application is filed through the remand lawyer or through the legal aid lawyer before the concerned court to reconsider the bond. Without much ado, I'd like to end this session, and if there are any questions, I will take it after my learned other colleague finish their presentation. Thank you, sir. Thank you.
Good afternoon, everyone. With the permission of Honorable the Chief Justice, I wish to begin my session on remand. A very welcome to our distinguished guest, Sri Deva, in this session. The topic of arrest, the bail and remand are so interconnected that most of the sections have already been quoted by my previous speakers. So I would not stick to the sections much and straight away move to the core issue, which more than a larger part of trial, if we consider the considerable time spent in the trial. But this issue, which is starts even before trial, has grasped the mind of all of us, including the police investigating team, the High Courts and the Honorable Supreme Court, that the topic of arrest, bail and remand has been a perennial discussion and on which judgments are galore. Now, today morning itself I thought that remand is a very typical English word, but the definition is related to law, which says that to send someone accused of committing a crime away from court until their trial begins. So this is the period where the accused is kept at a particular place if granted custody before he is subjected to trial after investigation. Now I want to present a broader picture into this. With my experience as Chief Judicial Magistrate, especially at Gangtok, the variety of cases was so much that it gave me an opportunity to introspect into what other people's feedback would be on the criminal justice system, the police officers, my colleagues in the other districts, and my senior officers. And of course, we belonging to a judicial fraternity, we have quite a lot of lawyer friends also, very close friends with whom we completed our college. So we do have discussion on these aspects. One thing that we must remember, because I have heard one of my colleague is a public prosecutor in a different state who has a different perspective of thought when it comes to law. So he says that, you know, the law is made for people who can twist it. And one fine day, Sri Sasteva also, when we were having a talk, he said that people have that perception. So is that true? Now, criminal law, especially the CRPC, I would still refer to this law as CRPC because we are so familiar with it. And let it be understood that I am talking about BNSS because nothing much has changed inside it except these section numbers. On one side is the state, which is such a huge agency, and one side is a person, especially in our state if you see, or even in other places, who does not even have means to gather as to what he will eat next day. A vast majority of accused persons do belong to the communities where, to the category where they are usually from the lower middle classes. If you see the jails also, you'll find that. If you see the drug accused persons, you'll see them. Their financial stability is not very good. It's not that it does not mean that the people from the higher echelons or the higher layers of society would not commit offense. So what makes that, and if you see the jails, there are very less women offenders, even at the accused state. Even if you go to jail, I think 4 or 5. So it's a thing to introspect why men are there more in the jails. What are the reasons behind it, right? This is a different aspect, but what I mean to say is the state is an agency which has all the police forces at various levels, beginning from constables or havildar to a rank of Director General of Police. And one side is a person who has to defend himself alone. So bearing this in mind, the CRPC, I believe, was engrafted, giving all the rights to the accused for his protection, so that an agency as big as a state does not trample upon a person who will find it difficult to defend against such a big body. And state involves everything, right? Not only police, there are political people as well. So it is because of this. So my argument with my friend was, yes, you are right when you say that the CRPC provides such rights to the accused, that he is of the view that it even hampers fair trial because everything is for the accused, they say. But the reason behind these provisions is the protection of the person who is at the down below or as well as the up to fight his trial against a big thing called state, where all the machinery is put into investigation to unearth the truth, so that a person who has really committed an offense does get punishment and the victim gets the justice. So in that perspective, I have written this defense. Usually if you see, and another common perception why people say so that the law is only for the big people who can twist it or whatever words they use, say I am not privy to what they are saying, is that law requires, when the accused is produced before the court, the accused requires a spokesperson. If you see some of the cases I have experienced as a CJM at Gangtok, the moment some persons were arrested, even the accused, before the accused reached my court for remand, bail petitions were ready to be filed. That does not happen with everyone. And there, of course, legal aid facilities are there, but a quality defense is required from the very moment the accused is arrested, so that he is heard in the court. Judges are also people. They can't sit like blank sheets of paper. We have our perceptions, our opinions, but that we do not bring in our duty. The law is the black and white letter for us, and the interpretations given by the honorable higher courts, the constitutional courts. And at times, most of the times, even at the trial courts, judges have to take their own decision, because not all in fact, there are very rare thing called precedents which come to your rescue. The facts are always different. And in the end, even if one refers to the precedent, the decision has to be of the trial judge in a particular point. I've rarely found two cases exactly similar. Very rarely. Of course, there can be one and two. So, in the broader picture, it's the state fighting against the accused, or accused defending himself against the state. Now, recently there has been a judgment from the Honorable Supreme Court. I am showing this the extent that the Honorable Courts, Constitutional Courts, look into this arrest. Informing grounds of arrest. This was never it was there in the Code of Criminal Procedure that you must inform the accused the grounds of arrest. But a judgment on this as to what would be the consequences if not informed had not come recently. I think it's this year or last, I think probably 2025 judgment. I could not trace the name of the case. I did not have time out there. This thought came into me while I was already in this room. Informing grounds of arrest, not formality but mandatorily constitutional requirement. So all these rights of the accused are flowing from the Constitution, which is the highest law of the land. And in fact, it is the law upon which we have taken oath, all of us here, by the very nature of our duties, to uphold it. Mere information of arrest will not amounting to furnishing grounds of arrest. So I am arresting you is not an information. Why I am arresting you is very, very important. And this has consequences. I'll demonstrate it as we move on, why the grounds of arrest should be mentioned. A routine arrest leads accused has been informed of his grounds of arrest. And for the magistrate, it's your bounden duty, in fact, even before this judgment, to ask the accused whether he knows the grounds of his arrest. Most of them will say, I don't know. Because, law in a sense is such that even if you are informing the accused that you are, accused of this particular thing under this section, and he will be not able to understand. So in the simplest manner, this is the allegation against you. At least the court should ensure that he would not understand under which section, what law, what punishment it is. But he knows the core reason for why he is arrested. That's the first duty of a magistrate when he is brought before the court. In fact, I think Juvenile Justice Act has an express provision on this. Now, as my previous speaker spoke about routine arrest, now the Honorable Supreme Court has said that the Supreme Court of India has recognized that an arrest can leave scars on a person's life, particularly when the arrest is unnecessary or based on weak grounds, impacting their reputation and causing significant psychological harm, even if they are later acquitted. This routinely happens with a person who does not have a spokesperson in the form of advocate in a court. We all abhor arrest. We cannot say, right, that we are in a certain position that, because offenses are of such natures that sometimes there are always a ground of being falsely implicated. And one can exonerate oneself only at the end of the trial. By that time, some years would have passed and the entire society would be looking you as an offender. That's one aspect. Now, when the question of remand comes, the foremost necessity is of custodial interrogation. An accused, when the accused is produced before a magistrate, he is not bound to send him to police custody, even at the first instance. Accused can be sent to judicial custody, or such custody, actually the criminal law states, to such custody as magistrate thinks fit. It does not define what kind of custody, though mentions police custody and judicial custody in this section, while determining the number of days that the accused can be sent to particular custody. But it does not say that the magistrate should send to police custody or judicial custody. It says such custody as the magistrate thinks fit. Now, in my experience, I have found that the easiest way to, and the fastest way to complete the investigation is extracting the information from the accused. Who could be a better person than him who can give you the facts, right? So that is one of the easiest form of starting the investigation. But the law says that if the offences are below 7 years, arrest is not necessary. So you cannot take the person to custody for interrogation. A hard work begins here of now looking for the evidence. So my practical experience shows that the arrest is routinely made because you can ask the accused, he will tell everything, and now you just need to go and find the evidence. That's all. The very next day, accused, I usually pray for 5 days minimum police custody, but if you give 5 days, the very next day IO comes, I am done with him, can you take him down? So the request for remand should be based on the specific facts of the case. If you do not require 5 days, just for formality, there is no requirement to ask for 5 days. Just because the offence is murder, you need not, if the offence is murder, usually 10 days remand application comes. Is that even required? It's just been 24 hours that the offence, the investigation has begun. You may just need it in for 3 days. So be reasonable with the demand which you make. Because if you ask 10 days, the court will again have to apply its mind and say whether 10 days is required or not. The wastage of time, even if it is a little bit of time. If you say 4 days, the court may say, okay, 4 days murder case is reasonable. So let's be clear on these facts. What the police needs, how much time you need. Of course, the court can grant up to 15 days and you can ask it up to 15 days. So I think the police should take care of the resorting to information extract from the accused himself for investigation should not be routinely resorted to. Custodial interrogation is required, and actually it's very exceptional custodial interrogations where the case cannot be moved further without asking the accused. This should be the necessity for asking a police remand. It is actually meant for custodial interrogation. Otherwise, you can interrogate him at house also. Why would you want to take into police custody? Because certain settings are required where the accused has to be asked. If you go to his house and ask, and in his all comfortable seat, he may not cooperate with the investigation. So a custodial interrogation is a recognized form of course, minus the other things which is not allowed in law. Now, one thing that surprises me till today is, the 24 hours given to the police officer since long time back in CRPC is still 24 hours. When the nature of crime has increased, the number of crimes has increased. So, personally, I believe 24 hours is a too little time to investigate into any kind of offences. Because actually CRPC contemplate police would initially complete the investigation in 24 hours. And therefore, the need of producing before the magistrate after 24 hours is only because you could not complete the investigation. But in 1973 also it was 24 hours, it's 2005 also it's 24 hours. But I do not know all the wisdom of the legislature that they have still retained 24 hours, that the police must complete your investigation within 24 hours. If not, go to magistrate and seek remand. In cases, of course, which are more than 7 years old. Accused, under section 187, which is the corollary of previous section 167, accused must be produced before the magistrate in person for authorizing further detention. So further detention, whether in police custody or judicial custody, can only be made on the authorization of the magistrate. Now for the magistrates, the authorization is a judicial function. It can be tested. If someone is aggrieved with the order of detention you have passed, and always approach the higher court with that grievance. In fact, some of the cases have reached even the Honorable Supreme Court, which I mentioned before, that not informing the grounds of arrest, Honorable Supreme Court has said that it is illegal and released the accused. So it's a judicial function, learned magistrates, and you must perform it judiciously. Maximum detention for a period of 60 or 90 days as the case may be. That is still retained in BNSS, the time of completion of investigation, after which accused has to be released on bail, which is also known as default bail, and he can be detained further only if he is not ready to furnish the bail. For the magistrates, when a remand application comes, you must ensure that the arrest is legal. Constitutional rights of the persons arrested is satisfied, that is he has been informed of the grounds of the arrest, a relative or a friend has been informed. This is very important because someone should know that the person has been arrested. Specific reasons have been recorded for arrest. Now we are discussing that up to 7 years, right? The law says we have to give the arrest, but I don't see why there should not be a reason, even if it's not a requirement or a parameter of granting remand, why there should not be a reason for recording arrest of a person, even if the offense is above 7 years. It's just a matter of one line. We all have reasons for doing something. So that would give a better picture even to the magistrate, even if the offense is above 7 years of age. Because even in certain cases, even when the offense is murder, the remand cannot be said, oh, this is an offense of murder, I'm granting it. Magistrate has to write something why he is authorizing police detention. And certain facts, even at that stage, is required. Because I'll tell you an example. When I was CJM Gangtok, the case is ultimately completed, the accused is acquitted. It was a heinous case of rape and murder, that too of a cousin by a cousin brother. So he used a lot of hue and cry from the public, and they finally, after some days, police could arrest 2 persons and brought before me. Then when I was looking into the facts that was given to me in the case diary, I saw no evidence against those persons. Some kind of evidence supporting, evidence not in a sense that is brought in the trial, but this is it, therefore it points towards it. I could not find anything there, except that I was told that the cert has been recovered from the accused person, which contains blood stains. So I told, how are you sure that those are blood stains? Then the police said to me, we have sent that to forensic. So do you have a photograph of that cert which you could show to me at least? Nothing was there. FIR, and it was such a difficult situation for me as a magistrate. The offense is murder. What if I don't give the remand and these people are real offenders and flee away? Now what if I give remand and they are not the people? So I could not sleep the whole night. I gave the police custody. Custody was sought for 10 days. I just gave 1 day. And tell me by tomorrow I need the cert and the photographs, whatever you are telling, and the forensic report, whether it's blood or not. The very next day in the morning, when I was somewhat scrolling the phone, I found that the real culprit has been arrested. Someone else. And those 2 who were brought before me were not the accused persons. So this is the very importance of remand. The very next day, on my one side, the conscience was telling me I should release these people. Even if it is an offense of rape and murder, I should release this because nothing points towards them. But the assurance given to me by the IO that there is a cert, though he did not produce me on the first day of remand, somewhat led me to, okay, I'm granting, and I had given reasons for why I'm granting the remand, with all the facts that though police have not brought before me, but considering the offense of murder and what the police are saying, I deemed fit to grant their police custody for 1 day. So the very next day, a different person was brought before me, and I thought I should have gone with my conscience, which was speaking deep down me. So it's not a simple function for a magistrate to decide remands also. And for magistrates, this should never be routine. Whatever the offense, it's above 7 years, blindly. Granted, because offense is murder, no. Just put it to some scrutiny, even a small one. Sometimes your conscience may be right. Now another thing is checklist. Yes, police do come with checklist, but it's mere reproduction of section 41 which used to be there. Mere reproduction will not work. It says there should be reasons why you reach that conclusion the person is arrested, like for the purpose of investigation, a very nice word which is usually used by the police officer. A very broad word, of course accused is required for purpose of investigation. But why in the facts of this case? His arrest is necessary, and without arresting him, we cannot proceed with the investigation. That should be an essential feature of the checklist, and not just reproduction of 41. That is not going to help. And there has been situations where, the police officers would come with this just reproduction of checklist. I, as a magistrate then, have given them time in the courtroom itself. Okay, if you have reasons, write it down. You can do that, magistrate, because, somewhere we have to be reasonable with the things that come. But not every time. It all depends on the facts of each case, the nature of offense, etc. Sometimes police do mention reason in the courtroom. But we said, where is it? Should be in writing. At least that is our record. So it's very essential to put that reason of arrest in your checklist, and not just mere reproduction of 41. Magistrate has to record the satisfaction of why he is granting remand or why he is not granting remand also, both on both sides, so that there is a clear picture to everyone that what played in the judicial mind of the magistrate. It's not just, it should not be that remand granted. Remand granted for reasons so and so. Now, trial courts, now we call it district judiciary, which consists of district courts, magistrate courts, etc. It's one of the very, I would not use the word powerful, but the court, which is the first door of justice. And even power is not a wrong word in terms of the power that law confers on the courts, right? There are constitutional courts as well, but trial courts are also very, very powerful in these matters, in a sense that the decision that comes out in the remand also should be a judicious. Your decision is the first decision, first order, and to challenge it, it will take time. So it makes a difference what you say in your orders. A stay to come from the higher courts will take time within that period, and your order is the first order which decides something. So you must be very careful on deciding these remands. Now, section 35. It was shown by my previous speaker, Sri Bhutia. This says that up to 7 years you must not arrest first, and you must have reasons for arresting the accused. Now, some things are very important here. Any police officer may without an order from a magistrate, of course relates to cognizable offence, arrest any person who commits in the presence of a police officer. There's no problem when the police officer offence is committed before him. You yourself is the witness, right? That's pretty clear, a cognizable offence. Or B, against whom a reasonable complaint has been made. Now, it's not just complaint, it's a reasonable complaint. Now, the other thing is credible information has been received or a reasonable suspicion exists. Reasonable, credible. Now, these three things first comes to the police. It is not that someone has lodged an FIR, therefore I must jump to arrest. You must have something in that FIR, or if some people do not know sometimes how to write an FIR. Okay? But your investigation has begun. Even if the FIR is registered, if the person comes, you will definitely inquire. Oh, the FIR has come, okay, I am registering it. Some might be cryptic, but the person may be complaining genuinely. So you will be asking certain questions which should lead to you to consider that it is a reasonable complaint and the information is credible. But the practice is quite different. The information is registered and thereafter the investigation begins. That's why I think the example given by Bhutia, was someone who filed a malicious prosecution, is at the end police knew, no, this was nothing, this was not about this person, right? So these scrutiny into even the complaints that come before the officer must begin from the time when the FIR is lodged. It's not that the final ending of the charge sheet is only the responsibility of police. Your finding of truth begins from the FIR comes. And there is nothing in law to assume, or even practically for police, to assume that when the complaint has come, the person is definitely an accused. There's no ground for such assumption, though usually those are the accused person. So begin from the application of mind starts from the police and then continues in the court. So where there is absence of application of mind, the thing goes haywire and malicious prosecution, like as Sir pointed out, comes. And I gave example, the very next day a different actual accused was brought. And I was convinced the next day he is the accused by the materials that the police sold. There's one aspect of public outcry, especially in the era of social media, but we have taken oath as a duty to protect the rights of the accused as well as a victim. So everything in us must start with absence of biasness. Just because there is a complaint, therefore the fellow is accused. Offences, we cannot stop offences. There are various kinds of offences, from small offences, offences against body, offences against property, like cheating, etc. Usually these offences occur when the relation between two people turns sour, usually in money dealings. These are, of course, it's in the law, it's a crime. But reasonably speaking, we need not see with that same lens as we see the other offences when it comes to offence on the documents. So arrest can be avoided here, absolutely. Now, another question that may arise in the minds of police is this 15 days period where you have your right to investigate the accused in custody. Can you take it after that first 15 days is completed? There was a judgment a long time back in the 2023 itself that the period of 15 days being the maximum period would span from the time to time with the total period of 60 or 90 days as the case may be. Any other interpretation would seriously impair the power of investigation. We may also hasten to add that the proviso merely reiterates the maximum period of 15 days qua a custody in favor of the police, while there is absolutely no mention of the first 15 days alone for the police custody. Even when the old law was there, now there's a clarificatory provision which says, you can take this 15 days at any time if it's an offense punishable with less than 7 years, or where you can detain him for 60 days, then within first 40 days you can apply for that 15 days anytime. If it's 90 days offense, then within this 60 days period. But even in the erstwhile CRPC, this was very much clear, because I'll tell you example why this was essential. Now the new law clarifies that those 15 days is not just the first 15 days, but any time within the period of 40 days if the offense relates to that 60 days embargo, and the 60 days if it's 90 days embargo. And of course these situations came in the past, and I have granted the remands even after the initial first 15 days, not extending the police custody, but they had not availed that opportunity of custodial interrogation within the first 50 days, and the application came later on because it made no sense to interpret it otherwise. Now, there is among the magistrates, there was usually a confusion with different judgments of, sometimes even the same benches or various benches, that when does the 60 days, 90 days period start? Now, this matter was ultimately referred to the Honorable Supreme Court, which in this case, by 3 judge bench, cleared the air. The date of authorization of remand by a magistrate is to be included in the period of computation for 60-90 days period under section 187 of BNSS. So from where to come? The date from the authorization of magistrate. There are judgments which says you have to exclude that date. There were judgments which says you have to include that date. But now this larger bench has given this clarification. So it begins actually from the day it's brought before you, that is after completion of 24 hours. This was the sensible interpretation which Honorable the Supreme Court have finally cleared the air on it. Now, Arnes Kumar was in 2014. Now, if you go to the facts of the Arnes Kumar, particularly in our country, every society, every country has its own kinds of law based on this society. Arnes Kumar case arose from a matrimonial dispute. And I do not know, I do not see in my places, probably we are not aware of it, but as I said, I have many judicial officer friends in other states. They say that the section 498A and other dowry provisions are so much of misused that it becomes difficult to contain. So looking into the larger scenario, the matter went in because of some, dowry harassment and, the cruelty. When this reached up to the Honorable Supreme Court, they saw it is not only this in these offences. These are offences which are punishable by less than 7 years. It's not only these offences, but every offences where the punishment is up to 7 years, there are routine errors. So that led to a broader judgment coming on this. But yes, as I said, I have quite a lot of judicial officer friends in the state of West Bengal. When we discuss about these laws, they say that you would not know the extent a person can be falsely implicated in these cases and incarcerated without any bail. So it's not that this judgment came just because out of nothing. There are reasons for this judgment, and it's very clear, Arnes Kumar, as we all know that by now. And that is the issue. Then Muhammad Asfaq Alam recently 2023 reiterated, and I think the magistrates are aware. If police officers are not aware, then let me display something here. This is the notification of our High Court as earlier as magistrates all are aware. 2023, just about 1.5 years back, the Supreme Court judgment Muhammad Asfaq said that, see, we have, since Arnes Kumar and the later on judgments have spoken so much about it, that arrest should not be routine, but still, what is in the mind of the magistrates that they are, despite the judgments, they are not they are routinely granting remands. Of course, there are practical difficulties which, considering the vast amount of cases pending in the magistrate court, there are courts, magistrate courts, where about 300 to 500 cases are listed with different nomenclatures. Some just routine daily functions, some that's not there in our state, but yes, it's not easy down there in the magistracy also. But that cannot be an excuse to ignore the law for police officers as well as for magistrates. If we ignore the law, and the High Court reiterates the disciplinary action that will be taken against the magistrates if they fail to adhere to the directions, guidelines in considering remand. This should not operate in the back of the mind of the magistrate. That's when honorable higher courts, when they pass a certain decision in a case, they usually say that the trial court shall not be influenced by the remarks made in this case and shall decide the case independently. This should, for the magistrate, should not be ordinarily in the back of the mind, and have a tendency to reject remand also. You be fair, judicious, what is the law, and the consequences, we cannot do much with it as long as you have done things in good faith. I think this is the only order from the Honorable High Court, notification anywhere in the country, or a judgment which says for acting judiciously you may have to face a departmental action. This was necessitated because the magistrates were not adhering to the guidelines. But as I said, don't keep this in the back of the mind, otherwise it might haunt you. But be judicious and forget about the consequences. You have to stick to the law. So for the police officers, this is as extent as the guidelines and the notification that exists when it comes to dealing with remands in the trial courts, based on the judgment of the Honorable Supreme Court. Sorry. Now, what are the types of custody? Police custody, we all know. Judicial custody means judicial custody. Judicial custody is granted. The police do not have easy access when the person is sent to the judicial custody. Still, there is no direct law which says you cannot, ask the accused questions in the judicial custody. Also, there has been instances in the past, practically dealing with the cases where the police had to be given some access to accused in the judicial custody as well. Transit remand, as we all know, and most of the people dealing with the trafficking cases would know about this. Theft cases where the accused quickly cross the Rampu border and you have to bring it. There was, I think in that particular case, transit remand are those remand. Now, whether transit remand is what type of custody is it? Is it a police custody or a judicial custody? Now, the Supreme Court, in the case of Gautam Navlaka, which was a heavily contested case, even at the initial stage of arrest, Gautam Navlaka being a civil rights activist. It was, I think, in Maharashtra case, and there are a lot of those things going on. So he was arrested. The transit remand was given. The Honorable High Court there stayed it, and it ultimately reached to the Supreme Court. A lot of questions, legal questions were answered, but the Supreme Court says that transit remand is a police custody. But on the other hand, the Honorable Supreme Court did not. Ultimately, what happened? The Gautam Navlaka filed a default bail application in the trial courts for completing 90 days in custody. Trial court refused. Matter reached up to Honorable Supreme Court, who refused to release him under 167 under default bail, saying that transit remand cannot be counted. But at the same time, the Honorable Supreme Court said that transit remand amounts to police custody. The reason was that the house arrest was granted by the Honorable Delhi High Court. And the Honorable Supreme Court reasoned that when Delhi High Court granted the house arrest, they did not grant it under section 167. Therefore, now you cannot come before me with application under 167 and say, though he had factually completed 90 days, including the house arrest. So transit remand, have been said to be a police custody. But on my own view now, when is transit remand taken? When usually accused either who has escaped from the jurisdiction of the concerned place where the offence had committed, so he has to be brought. Probably he is not brought in a flight by police officers so far, I think, except in some cases where he has to be brought and there are arrangements made for it. Usually you will bring them in train. I have seen cases where accused are brought as far as below as Chennai and Bangalore. It's a 3 days train. Okay, and in the and all those travel journeys of even police officers are people in the train. You would not like to interrogate, right? There's already a journey. So what about the loss of those 3 days if it's a police custody? I did not interrogate him in custodial interrogation, but I'm afraid as the law stands as of now, that period will be counted for deciding 60 days or 90 days. Some kind of new approach is required to deal with this situation. Whether the loss of 3 days in traveling, because the law on the other hand says the travel time should be excluded from that 24-hour period. So this is a little bit of area which maybe will have some judgments. Magistrates might face this situation. There might be accused persons who would challenge that transit remand should not be considered. Police might challenge transit remand should not be considered as a period of custody, because if the traveling time takes 15 days, then 15 days is gone. So this is a grey area. Now another thing that I've experienced is what is in hospital custody. I have seen in many cases, moment the person knows, right, influential person, moment he knows he's going to be arrested, he is there down with high BP. These are practical problems I'm talking about from the viewpoint that I have seen it. Because we as we are not just sitting for accused persons. We want the truth and the justice. So that used to make me think, the fellow is sitting down there for 3 or 4 days, or sometimes 15 days is gone there. And what custody is that? The police come with application before the magistrate after 24 hours. We grant either police custody or judicial custody. Now I grant police custody. Police cannot interrogate there. Police custody is granted for custodial interrogation. There's a guard outside sitting there. Doctors would not allow to question, and usually the reason is high BP. Now sometimes I used to feel, is high BP a reason for going to hospital? The jail has doctors. So and what police should check on this is even the medical reports that might come could be routine. And the magistrate is bound now. He cannot take the place of a doctor and opine something else. Right? There is always a fear of accused dying. And when death is there, even suicidal, some kind of inquiry will begin. Judicial inquiry definitely begins. So all these things are there. So magistrates are not just sitting there, without thinking anything. There are so many things to consider when remand is considered. So hospital custody, I do not know, we can discuss after this session. The police officers are there. If 15 days the accused completes in hospital custody without interrogation, and after police cannot come with asking to the magistrate, I want to interrogate him, then what happens to the investigation? It has happened in the past. Some people have spent jails in hospital, if I'm not wrong. The conviction period was already computed in hospital. So these are issues, of course, right? So we can talk about hospital custody, what police would try to tell. And after the 15 days, the person's BP is, everything is okay. And these are practical things which I've seen as a magistrate. And another thing that the magistrate would see, now even the BNSS says that the accused have to be produced before you at first in person. Right? Magistrates can discuss this. But when the accused goes to hospital, you cannot insist him to bring with bed. So either you have to do VC, but the law only allows VC in the judicial custody. Police custody, it still says every time the police is producing before you within that period, he must be produced in person. But practically being impossible, we have, I think, considered that, and have written that accused not produced in person, but this is the so and so case, and through some measures we ensure that the accused is all right. Now one more practical example which I see in our state is that FIR is registered for certain offences, let's say 354, and later on some more after investigation it is found that there's 376 also. I have dealt with this particular case when the POCSO court had already granted bail to the accused. The accused was arrested by adding a section and brought before me. So I was aware of, there's even a previous judgment than this, they were aware of the judgment. Mere addition of a graver section does not entitle you to arrest the accused in the same case without cancelling the bail from the court that granted the bail or taking permission from that court which granted the bail. So as I am saying, giving example, if it's a case of 354, in the same case you investigate, you find 376, you cannot just go and arrest the accused, the bail has to be cancelled. There are about 3 judgments on this. Now, in the end, what I want to say is, the law which we have as of now is not our creation. It's the creation of the legislature, who theoretically, if you go, people are the lawmakers, and it is the legislature which actually does the job. And the law which we have is the people's voice. We cannot change that unless the legislature changes. We can have our personal opinions, our perceptions, everything, but our duty is to stick to the law. Especially the trial courts, when we either look into the law, interpret ourselves, or look into the judgments of our immediate High Court. If not available, then to the Honorable Supreme Court to guide us, right? I cannot say that I have a certain perception about society. I cannot say that for me the most heinous offense that I feel is theft. A person has worked his whole life and overnight everything is gone. Of course, the human body, offense against human body is also one of the heinous. So I personally may not like a offense of theft. I do have that perception. But when I have to sit as a judge, I cannot bring that perception into it. So same with the police, I believe. We may be having our personal opinions, our perception, our obligations somewhere else apart from the duty to do something in the cases, right? But I think there is a need to balance and accept the law which we have today, unless it is changed by the legislature or the constitutional courts. It is balancing the constitutional rights of accused, the liberty especially, and more so in the days of social media when we can talk and say anything. If you go to social media, there are so many offenses if you go literally by the law. Okay, especially in the laws that deal with obscenities. So should we go and arrest everyone, right? So society is evolving, but the law that we have is a little bit tardy. I myself feel that in about years to come, the present generation which we are will even be unable to comprehend what the younger generations are thinking. The law should be from that viewpoint, right? It's ever evolving and changing society. Yes, the investigation is very essential for fair trial, not only for the victim but for the accused also. The law protects the innocent actually, and not the real culprit. The problem lies in we are not gathering evidence to convict the person. If on the one point of view, if it is said that the people, the initial crowd that swells up when hears about offenses, especially sexual offenses, sometimes I wonder why people only protest against sexual offenses being committed and not other kinds of offenses. Corruption is one of the offenses which needs to be protested against. But when it comes to sexual offenses, people jump. And sometimes I feel, I may be wrong, the very much likelihood predators would be there in that crowd. So let's be practical about it, that very crowd thins as the trial progresses. And sometimes, as I said, that rape and murder case of a cousin, there was huge hue and cry in the social media and medias also, the electronic prints, the paper prints. But when acquitted, no one even heard about it. So I would request the police officers to also publish the list of convictions and acquittals in the cases, so that everyone is aware. Actually, the failure lies in why the people and the society would actually lead to these protests is that they see very less convictions. And conviction is not something unattainable. If we see, I'll give you one example. If 5 minutes is given to me, see, I have dealt with vigilance cases. The same police officer who investigates while he was in police station does not investigate with that zeal, or the investigation is not of quality. But when investigation comes from the vigilance police, though there are acquittals in vigilance cases also, but the standard is quite surprising. You would not be expecting that surprise. So one day I asked one police officer who was in vigilance, and I dealt his cases while he was in police station. I asked him, he did not reply to me, but I felt, there the whole job is to investigate. Probably, I do not know, police would know this setting. Mr. Sachdeva may like to highlight on this, why at least we can see the difference in the investigation quality when that comes from the vigilance police and the normal police stations. So there are things that has to be introspected on the police level also. As we see, we do not have a proper forensic lab in our state. All the forensic material goes to another state, and sometimes it takes years to come. And by the time I have seen cases, the report comes, they say the collection of evidence was not under SOP, and the samples cannot be tested scientifically. Whole lot of wastage of 3 years. So these are the places where improvements are required. And I do not know, there has been a lot of recommendations since long time back throughout the country that police force needs modernization. So the lacking areas are here. Not that accused should be arrested and put to jail. It will not improve anything. How long will we keep him in jail? 90 days at the maximum. And as I said, on acquittal no one reports it. So there is an optimal rate of acquittal throughout the conviction throughout the country. This needs to be improved for people to have confidence in the police system. Because of these, people might lose faith in the judiciary also, because ultimately what will be said is the court which acquitted. No one will say that police did not investigate. They will say court released it. POCSO cases have been acquitted in the high courts. Right? So just because of small thing as the minority could not be established. Now there are so many ways of establishing minority of victim. Why these loopholes are there? This needs to be looked into. As I said, we all have our own perceptions. Should we mix our moral values and our perceptions with the duty which we have as a judge and as a police? I would say no. Except at some places where where the law matches with what you are thinking about. So moral values we may be having, but as a judge and as a police, our duty is to uphold the law, and we are not social activists. We have our own duty of upholding the law. That we can be outside our duty, but when it comes to our duty, I think we have to uphold the law, and the responsibility of making law is of the legislature, which the Constitution have granted to them. Therefore, I think we should stick to the law and not try to project that we are doing something for the society. Our duty itself is upholding law itself is our societal duty, instead of trying to change the moral values, etc. So with that, I think I would thank everyone. Satyamev Jayate.
To all of you, I had requested the Sikkim Judicial Academy to have this special program, basically for a deeper understanding of two Supreme Court judgments. One was in the year 2014, which we commonly refer to as the Arnes Kumar's case. And the other judgment was the Satyendra Kumar Antil's case. I had the pleasure of listening to whatever was spoken by very learned resource persons who are learned in more ways than one, apart from being very experienced judicial officers. Each of them have their special expertise in understanding law as it should be understood. Why did I bring this topic here? And why did I want the police, right from the highest police authority of the state to other officers down below? And why did we have the judicial officers? The reason is to understand what is crossing their respective minds, their fears. And this is exactly the reason why I am holding this interactive session. I would request the learned
Director General of Police of the state of Sikkim, either he himself or through any one of his very competent group of officers who are assembled here, to flag one by one the causes, the fears or causes of concern faced by them in real situation. Because I must hasten to add, neither Arnish nor Satendra have gone into specifics. As all of you know, and it has been highlighted by one of the speakers, that the genesis of Arnes Kumar was a matrimonial dispute under 498A. And it is in the backdrop of 498A and the way 498A has been abused generally, misused generally, the Supreme Court came up with certain guidelines. I must also tell you that not every utterance of the Honorable Supreme Court is the law of the land. Not every utterance. I will give you an example where the Supreme Court laid down the law of the land because that law was not at that point of time enacted by the Parliament. I am referring to a very celebrated case, judgment, which is in short referred to as the Vishaka judgment. And it is in Vishaka's case, the Honorable Supreme Court laid down guidelines which were required to be looked at as law till the Parliament came up with legislation which dealt with sexual harassment of women at their workplace. We often make a mistake of how to read a judgment of the Supreme Court, both in the magistracy and in the law enforcement side. I have found, much to my dismay, that the moment the Supreme Court judgment comes, both the sides who are not exactly in conflict with each other but in the way complementing each other, because in criminal justice system, the police actually has a very, very, very limited role. The police's role is to present before a competent court evidence in order to have an accused prosecuted for a crime or for some reason which can be considered as a crime within our legal framework. And it is the judiciary's role to sift through that evidence and find out whether it is enough for conviction or for an acquittal. Unfortunately, pronouncements of the Supreme Court scares most of us, and precisely for this reason I would call upon both the sides, as I said, which actually complement each other. One cannot exist without the other, to bring forth their respective apprehensions while reading some of the judgments of the Supreme Court, particularly Arnish and Satyendra Kumar Antil. So I would request the learned, the Director General of Police, either himself or through any of his officers, to share, and we will immediately try to address on that.
Honorable Chief Justice, the chief guest of today's August function, honorable members of the legal fraternity assembled here in this August gathering, my colleagues from Sikkim Police, ladies and gentlemen. First of all, I am extremely grateful to the Honorable Chief Justice. Sir, this is your initiative. Thank you, sir. With your permission, I am comfortable here. Thank you. And then you can come. Thank you. Sir, I am so grateful to you because it is under your stewardship, your benign guidance, that Sikkim Judicial Academy has provided a platform to the law enforcement officers and the learned magistrates to come together and on the same platform share their experiences, also share the shortcomings of the law enforcement agency, and also listen to what are the challenges the law enforcement officers are facing during the implementation of the law. And as you, sir, very rightly said, that both these pillars, the judiciary and the police, prosecution included, are pillars of the criminal justice system which are actually meant to deliver justice to the society. The purpose is to give justice to the society. We are together in this. And the two components, one side is the accused and one side is the victim. Under the new laws, basically, as the Parliament puts it, the Parliament puts it that now the emphasis has shifted from penal to Nyay, Indian Penal Code and Bharatiya Nyay Samhita. The emphasis has shifted to Nyay. So therefore, the previous maxim was that let 99 accused go scot-free and let not one innocent be punished. But then what has happened in this accused-centric scheme of things, that victim was left apart. And then the society as a whole also started feeling, as Mr. Benoy Sharma was also putting it, it is started appearing that people who can arm twist the law, who have the resources, who can hire very, very learned lawyers, under the same laws are able to get scot-free. Today we are deliberating very important two judgments of the Honorable Supreme Court. The judgment of Arnes Kumar versus State of Bihar and Satyendra Kumar Antil versus CBI. And sir, I am very sure our officers have been profoundly influenced by the wisdom of the learned speakers, and the various points which have been told are definitely the points which we have been stressing again and again in our refresher courses. The police does agree that arrest without an application of mind is absolutely, absolutely wrong. We do understand, and Supreme Court has very rightly told all the law enforcement agencies of the land that you need to have applications of mind. Secondly, in judgments where it is less than 7 years or equal to 7 years, there has been a checklist provided which the learned magistrates, the learned session judges, they have also reminded everybody, and the various sections under 41 1B sub 1 and present 35 BNSS have also been brought to a notice. Now sir, this is the foundation on which the police is also working. But now what the challenges are happening, and sir, I would like your permission to be a little forthright and honest. Sir, what is happening right now? Yeah, because that is what the officers are saying, and being the Director General of the Police, I need to bring to the knowledge of the learned magistrates and the judges. What is happening is there is this clause that when you are going to arrest, and there is a proper checklist, and we saw learned principal sessions that very elucidatingly explain to us that how when you are giving these checklists, if you give those reasons in writing, and that is what the learned Registrar General was also trying to emphasize, that there is a checklist, please give the reasons in writing. But now, there is a confusion which is coming in the mind of law enforcement agencies, and it is their perception that this is also existing in the minds of learned magistrates, where it is being believed that even if you write something in the checklist, since you have already arrested, let us say, the previous day and producing the next day, the fear which is coming is that it would be taken against you, and in case of police, a departmental action can be initiated, and as it was being mentioned, a learned magistrate can also be hauled up by the Honorable High Court. This is the reality of the fear which is coming in the minds of law enforcement agencies. And therefore, I can talk about the state of Sikkim, sir. Sir, now what has happened is officers have become, one is abundant caution, it is extra cautiousness, to the extent of rather let go people, do not arrest, do not do that thing. But now that has started impinging on the law and order component. In the state of Sikkim, a lot of drug peddling is taking place, and a lot of youngsters are getting involved, and they have started taking a lot of advantage of these laws. Secondly, different points of time, cases of writings get registered because political factions of different political parties fight against each other. They throw stones, bricks, and that is the time, if arrests are not made, all these sections, all these subsections are satisfied in those cases. But if we don't make arrests, then the same society where justice not only should be done, but it should be perceived to be done, then they start pouncing on the cops in the media and the social media, saying that either the cops are afraid of these big people who are indulging in these offences and not arresting, either allegations of corruption will come, that they have some pecuniary advantage which they have taken, or plain they are so scared of them that they are not able to take action. Second domain is in the case of property offences, in burglaries, in thefts, where, as it was being said, Mr. Benoy was saying that to his mind it is one of the greatest offences, very right. Right now there is so much increase in the spate of burglary, so much increase. Gangtok, Ranipul, Pakyong, Singtam, Rangpo, houses are being burgled left and right. And there are two categories. One is juveniles, they are entering this, and others who are also not juveniles, but they are taking advantage of these situations, and there is a scare factor in the minds of officers that if I arrest and put them behind bars, and even if with a checklist go and take them to the magistrates, probably I may be still hauled up either by the courts or by my own department, and we will face trouble. So they are choosing the path of least resistance, or they are starting to choose the path of least resistance. Better is not to arrest. And I don't think, as the Director General of Police, this is in the healthy interest of the society, not in our interest, not in the court's interest, and not in the interest of society. Because if criminals start enjoying all the benefits for which the Supreme Court never intended those judgments, I think then it is a misinterpretation of the judgments that we are making. So, sir, I am just making this base case scenario, and I would like sir to enlighten us, and then 2, 3, 4 officers who are from the field, they can also share their experiences where the learned magistrates can then respond. Thank you so much for giving us this opportunity once again, sir. And it is with your guidance and support that at least we are on the same platform, because in the courts, everything is to be tested on merit. Everything will be tested on merit. But it is this platform where, in a very informal way, we can also share our challenges and ask solutions from the judiciary. Thank you.
Thank you, Mr. Sachdevan, and thank you for sharing your apprehensions. In fact, this is the purpose of this program. Let me also assure you, as much as there is apprehension from your side, there is similar apprehension from magistrates, and I have come today to clear those apprehensions and empower both the sides adequately so that at least substantially your fears are allayed. When I started speaking to you, I said that not every utterance of the Honorable Supreme Court is the law of the land. About a year or so back, in this Judicial Academy, I had a closed door session with judicial officers on how Supreme Court judgments are required to be read. I had referred to one judgment of the Supreme Court, only one, in order to drive home this point that any judgment either delivered by a constitutional court or the High Court, in High Court we are both constitutional court and court of appeal. Constitutional court means court which deals with matters which are brought before us in the High Court under Article 226 of the Constitution of India, and in the Supreme Court under Article 32. The difference, I will take 2-3 minutes time to make you understand that the system of the legal system that we follow, and significantly, I'll come to something little later. The judicial system we follow comes from the Anglo-Saxon judicial system, which originated from Britain, which is not ours. And I do not know whether all of you know, but the judicial side will know better, that Britain till now does not have any written constitution. It follows law through jurisprudence known as common law. What is common law? Common law is the law that evolved over a century, period of centuries, which was accepted by the Crown as the law of the land. However, common law being a law in abstract, nothing statutory, nothing written, it was always open to being interpreted by the English courts or the British courts. And what they interpreted in the form of judgments were known as precedents. When our court systems evolved during the British rule, we adopted this Anglo-Saxon jurisprudence or Anglo-Saxon justice delivery system or Anglo-Saxon method of judging. Because we didn't have a constitution, we were a colony of the Britishers. We followed the common law system, the common law practice, and started our own Indian jurisprudence over it basically was from the second half of the 19th century and progressed till we got our independence, and even beyond that, till we gave for ourselves the Constitution of India. Now, I have been crying hoarse and trying to tell everyone that there has been a paradigm shift from that common law era, the day we gave ourselves the Constitution of India, adopted it in 26th January 1950. What we did on that date has a bearing on today's program. We migrated from a common law regime to a statute law regime. In other words, judge-made law, as common law is known as, gave way to real statute laws. However, we had a problem. We had a problem till very recently. What was that? Some of the old colonial laws, such as the Indian Penal Code, such as the CRPC, although it was drastically amended in 73 maybe, or 78 or so. 73 and subsequently 77, something new amendments. These were the baggages of the past. I do not know, one of you, I think, either the DG or one of the speakers said that the penal provisions have now been given to NAI. There is a shift. Unfortunately, Supreme Court has not made any pronouncement on that shift till today. The mindset of we, the constitutional courts, which is also the Supreme Court, will take some time to change. It will take some time because this BNSS or whatever, very difficult to pronounce names, the new laws are asking the court systems to change the way we look at law. We have till now no pronouncement on what I am now telling all of you. So in this backdrop, why is it significant that we look at these two judgments in a different light? As I said at the outset, and I kept on repeating, I think once or twice, not every utterance of the Supreme Court can be construed as law. The utterance of the Supreme Court in Arnes Kumar is based on certain facts which may not be at all relatable remotely to the facts as you present before your magistrate in case of bringing an accused before the court for a remand request or whatever be the reason. As I said, all of you know, Arnes was a 498A case. And I said this earlier also, 498 was one of the, or is one of the most misused provisions, not in this part. And the other thing is, please for heaven's sake realize that Sikkim is not a colonial baggage. Sikkim is completely unique and different. It has been given a special status and cannot be equated with Kashmir just because there is a similarity in Article 371 or 370. See, this is 371K. This was a very peaceful kingdom nestled between two mighty sovereign entities, India and occupied Tibet, which I'll say was occupied by China and still is. And the law and order that was prevailing perhaps has no comparison with the rest of the country. Nowhere. I have done my little research on it, I can tell you. So, to say that Arnes Kumar or that Until's case will strike at the very root of an independent and robust functioning of the police as the investigating on the enforcement authority or the magistracy. And the magistrates being scared because of one paragraph, the High Court will initiate disciplinary program. I can tell you, no Supreme Court can give that order to us because High Courts are not subordinates to the Supreme Court. We are a federation of state. I have to also give you a little, that's why little bit of constitution. The chief minister of your state is not subordinate to the prime minister of the country. The chief minister is the highest political executive of your state. The prime minister is the highest political executive of the Union of India with certain privileges and powers which are not given to the chief minister. For example, national security, the army, the borders, currency, external affairs. These are all domains of the Prime Minister and the CM cannot encroach upon it. But beyond that, no CM can take direct orders from the Prime Minister, neither the Prime Minister will issue direct orders to the, unless, of course, there are some emergency provisions. I will not go into those. And the Supreme Court does not have administrative superintendence over the High Courts. But conversely, the High Courts have complete administrative superintendence over all the courts subordinate thereto. I am just quoting one or two words from the Constitution. Which means that so far as the district courts are concerned, the subdivisional courts are concerned, we don't have taluka courts here. The magistracy is concerned, they come under the direct supervision of the High Court. Therefore, the Supreme Court cannot direct me under the Constitution to start disciplinary proceedings against a magistrate. It is entirely up to the Chief Justice of a High Court to see whether there are good enough reasons to proceed against a magistrate. In exercise of the powers conferred on the High Court by the Constitution under Article 235 of the Constitution. That similar provision is not there so far as the Supreme Court or the Chief Justice of India is concerned. Yes, the Chief Justice may write a letter to me requesting some action. The Prime Minister may write a letter to the Honorable CM for requesting for action. Those are different. Those are requests. But we are a federation of state. So far as the magistracy is concerned, I am a little disappointed because neither the new magistrates are there and only one or two magistrates have come, and I will have to have a session again with all the magistrates and with more judicial police officers in order to drive home these very important points. Just because two judgments of the Honorable Supreme Court are swinging back and forth, they are not meant to take away the power that, and the authority and the jurisdiction of either the law enforcement agencies or the police, as we call it generally, or the magistrates. Magistrates are getting scared because of disciplinary proceeding, and the police are getting scared of checklist, or these are issues. I would hasten to add a caveat here, and this is just a caution, both for the police and for the magistrate, that whenever, and this has been highlighted I think by Benoy, whenever either of you do your job, for heaven's sake, apply your mind. Don't do it mechanically. Don't make the process of administration of justice look a bit foolish in the eyes of either the court or, in case of the court, before the public. Because both of you will ultimately be accountable to the public for any inadvertent mistakes you make. I know, so far as Sikkim is concerned, not only, I've just been, DGP has highlighted about burglary. Immediately the question that came into my mind is why there has been a sudden spurt. Why? It could be because, and most of them are juveniles, so my analytical mind would say that maybe it is fueled by requirement of money for buying drugs. Maybe it is fueled by requirement for funding a better sort of life for them, something of that kind. And so far as some of the nuisance makers are concerned, they are even smarter. And this is where I would use this Rompo example. They will say something, use the social media, and then run away across the border, making life miserable for the police to nab them. And when they nab them, and they have come before the magistrate, I think the magistrate requires to know, and for that a note or a memo of arrest prepared should highlight what you went through till the process of apprehending the culprit. A little summary of what you did. You had to catch a flight from Bagdogra to Delhi, from Delhi you took a taxi to Gurgaon, and you came back when he had already escaped to Jharkhand, so you had to come back to Gangtok, file a report before the higher authority. The higher authority gives you permission for going back to Ranchi, and from Ranchi you had to say that he is almost reached Purulia, and from Purulia you catch him. What is happening? You spend 15 days or 20 days or 1 month, I don't know, in order to apprehend a person and bring him before the magistrate. And if this background is known to the magistrate, then it becomes easier for the magistrate to deal with the situation and not get scared that Arnish says that the checklist is incomplete, so grant bail. So it has to be in my words, a very symbiotic relationship between these two, complementing each other for the purpose of administration of justice and for the cause of justice, which is Nyay-kendrik, Nyay-centric, not penal-centric. This has to be understood. I thought that I will use another day to speak on this, but there has to be a complete change of mindset. The colonial baggage has to be thrown away, and one has to understand why the parliament, after 70-80 years of independence, came up with these three. Yes, judicial officers will say, this is just a reproduction of that 41 is coming as 38 and so on and so forth. But it is more than that. We have given the statutes a new name, a completely different outlook. It's no more criminal procedure code, a Nyaya Sanhita, whatever it is called. Nyaya Suraksha Sanhita. So, what is Nyaya? Nyaya means justice. This concept has to go into the minds of both the prosecuting authorities, the enforcement authorities or the police, and the magistracy or the district courts where the trial comes. If this mindset changes, and if as a prelude to the checklist, a short note is prepared, I would say that things will become different. I will request the Director General Police to circulate one judgment which I was referring to, which actually has nothing to do with the law that has been quoted in that judgment. It was something to do with a labor court order. It has nothing to do with. Very interesting. And there was a reference to the labor court. The presiding officer of that court held that the law department was an industry in view of what had been stated by that court in relation to various departments, hotels, schools, public works department and education department. This view was accepted by the learned single judge of the High Court, who held that there was no scope for interference under Article 226 of the Constitution of India. This is the background. The division bench of that same High Court, it is actually Rajasthan High Court, after referring to some provisions of some statute, held that the view of the labor court was correct. And then the definition of a workman was looked into. So the Supreme Court, while looking into the matter, observed in paragraph 10 of the judgment that the Labour Court and the High Court have not even indicated as to how the law department is an industry, merely stating that in some cases irrigation department, public works department has been held to be covered by the expression industry in some decisions. This is the background. It has nothing to do. Thereafter, the Supreme Court starts relying on some of the most celebrated English decisions as to how you should look at precedents. And this is what the Supreme Court says. And I'll read it out, and of course I'll share this judgment with all of you, both sides. Reliance on the decision without looking into the factual background of the case before it is clearly impermissible. In other words, just dangling Arnish in the nose of the magistrate or until does not mean anything. I repeat, reliance on the decision without looking into the factual background of the case before it is clearly impermissible. I'll pause here and say, the background of that case in Arnish was a matrimonial dispute under 498A, which is, I think, cruelty something. The background of your case would be that this man was playing hide and seek with the law enforcement agency for 1 month. This is our note. Kindly peruse it. Our note says that we got a tip that he is in Gurgaon. We took permission, we went from Bagdogra to Delhi, Gurgaon to Delhi to Gurgaon, and from Gurgaon we came to know that he has escaped to Jharkhand. We come back and report it to our superiors. This is all hypothetical, of course, you can understand. The superior gave us permission to go to Ranchi. When we reached Ranchi, it said that he has left the nest and is now travelling towards the Jharkhand Bengal border, Purulia district, a place called Jhalda. He is about to go there, reach. We go into a car and somehow managed to get him either at Jhalda or just before that. If this little thing note is there before the checklist will assume worked into insignificant. You can simply add a line. The bona fides of the accused in the backdrop of what has been stated herein above is therefore suspect. The conduct of that person, if I have nothing against me, why should I run away from the law? Why should I run out of justice? So this is why I am saying this judgment which will empower both the law enforcement of the police and the magistracy to understand that just because Arnes Kumar says disciplinary proceedings will be initiated against the magistrates by the high courts without even looking into constitution, I would say would mean a travesty of justice if it instills fear in the minds of the magistrates and compromises with their decision to function independently. And here I would repeat what I had repeated 3 or 4 times in my career when I took oath in 22nd June 2006, then again when I became a judge of the Allahabad High Court, and then again when I became a Chief Justice of Meghalaya and then Chief Justice. The constitutional oath which I took is without fear or favor, affection or ill will. So if you have this mantra in your mind that you will do your job without fear or favor, affection or ill will, and if the magistrates also can perform without fear or favor, affection or ill will, it will be a new beginning for both. So, what the Supreme Court would say is a decision is a precedent on its own facts. Each case presents its own features. It is not everything said by a judge while giving judgment that constitutes a precedent. It is not everything said by a judge while giving judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate from it the ratio decidendi. Now these are so basics. I have unfortunately in the last almost 20 years as a judge and Chief Justice for 5 years or more, found any judicial academy discussing ratio decidendi. What is ratio decidendi? Ratio decidendi is the reasoning behind the decision. No one looks into it. No scholarly discourse on ratio decidendi. So this is where our side is going wrong, and this is where we are getting scared. And so far as all of you are concerned in the prosecuting side or the law enforcement side, I would also request you to apply a little bit of mind, which has been, I think, time and again spoken, and prepare your brief in such a manner that the magistrate will have no option but to follow what has been held again by the Honorable Supreme Court in state of Rajasthan versus Ganeshilal. I will not discuss this matter beyond what I have said, because all the or I can read this paragraph and would share the judgment with Mr. Sachdeva, who will again then circulate it. According to the well-settled theory of precedence, every decision contains three basic postulates: finding of material facts, direct and inferential, and an inferential finding of facts is the inference which the judge draws from the direct or perceptible facts. Statements of the principles of law applicable to the legal problem disclosed by the above facts, and judgment based on combined effect of the above. A very important sentence comes here. A decision is an authority for what it actually decides. What is of essence in a decision is its ratio, and not every observation made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone binding as a precedent. Then there are references to cases. A case is a precedent and binding for what it explicitly decides and no more. The words used by judges in their judgments are not to be read as if they are words in an act of parliament. In Queen versus Leatham, Earl of Halsbury, Lord Chancellor, observed that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which are found there are not intended to be the exposition of the whole law, but governed and qualified by the particular facts of the case in which such expressions are found. And a case is only an authority for the proposition for what it actually decides. I will not trouble you or burden you with anything more than what I have said. I will request both the sides to read up this judgment carefully over and over again, so as to get out of the misery of being confronted with the observations made in admission until his case, but with a caveat that just this is not enough. Please, both the sides, apply your mind and not consider that the case, as I cited, where the person is playing hide and seek with the law enforcement agency, running up to Gurgaon and then to Ranchi and then to Jhalda, can be equated with a 498A case. So you have to, the onus shifts on both the sides. So far as the onus on the police is concerned, I would say that along with the checklist, if you give a synopsis on the manner and mechanism in which was adopted by the police in order to nab, I am sure the magistrates with their legal wisdom will be able to sift the grain from the chaff, and they will be able to find out that this person cannot be let at large. I would request the magistrates also not to just catch a few sentences from some judgment in order to give a reason. You have to also understand that the police are actually working, in fact, in some cases with an overburdened load of work in order to nab a culprit, and that cannot be let go by this process of just referring to one line or two lines from the judgment. So I would request the learned DGP, I am giving you 2 copies of this print, you can circulate it, and I am also requesting the Judicial side Registrar to come up on the dais and collect this and ensure this judgment which I have referred to, and give the folder to DGP. Circulate amongst all judicial officers. Address it.
Good afternoon, sir.
Good afternoon, Mr. Lynch. Tell me.
Permission of Honorable Chief Justice. So I think before this meeting, I think all of us were pretty much battling with the issue of how exactly to put it across. And I think after this meeting, once Sir expressed in kind of a summarized version of what all of us were feeling, and the way Honorable Chief Justice explained to us how exactly to go about it, I think it is pretty much very crystal clear for all of us. I think all the queries that we have are very minimalistic and very, very specific case-based. And Sir gave us a very, overview of how exactly to go about this. So in view of the 1 hour interaction post the 3 sessions, I think all of us sitting over here are pretty much clear how to go about it. For that, I would like to thank the Wangchuk as well as the resource person as well as Abhi's.
Thank you, Mr. Lecture. What I propose to do, and Mr. Sherpa, please take a note, that I need a follow-up meeting, and this time with larger participants of the magistracy, on a day which is a scheduled holiday for the courts, here itself. And I will request Mr. Lecture to do a bit of homework till the next this kind of meeting, because I want to do a follow-up and try to find out from the ground level what is the situation. Is it the same as before? Is it improving? Or where it requires the attention of mind in order to resolve those issues. Please try to ask your subordinates to, because the arrests are not made at your level, they are made at the IO level. So please get some inputs and see if there are 1 or 2 instances where there are aberrations. If you can bring it to our notice during a follow-up meeting where I will have a better magistracy presence, I will be able to take these 2 sides of the same coin closer to each other. So, anything from your end? Yes, please.
With your permission, I would just like to highlight...
First introduce yourself because others would not.
I am Urushi Pradhan, CGM Pakyong. Lordship, with your permission, I would like to highlight on 2 aspects, Lordship, with regard to what my court has been facing. Recently, as we are all in pursuit of justice, that has been crystal clear right now. So, what has happened is that there was 2 FRT filed from 2 different police stations in my court, and it was of theft case. So, FRT was filed stating that the person was not nabbed, the articles were...
What would FRT mean? I am Greek to it because I am a constitutional judge. Tell me what is FRT?
It's a final reporting.
Say that.
Final reporting.
Unfortunately, I have not worked up from the magistracy. I was just caught by the Chief Justice of Calcutta High Court when I was a 42-year-old and said you have to come this side. So that's how. So I don't know anything about FRT.
So FRT is basically where a police officer would file closure reports stating that a person could not be apprehended or there could not be any incriminating evidence found against a suspect or something like that. On that ground, they file a closure report. So with regard to theft case, the closure report was filed in 2 different cases from 2 different police stations stating that a person could not be apprehended, and in another case, articles stolen could not be retrieved.
Two different police stations in respect of 1 case?
No, Lordship, different cases. different IOs. So, and then as the procedure mandates, I examined the complainant and the victim as well. So the complainant came and informed that, under the oath, came and informed that the article was retrieved. The person was apprehended, and the apprehended person was put in jail, and then the identification was done. All those things were done. And then the closure report comes to the conclusion that no apprehension, no arrest was done, neither was the article retrieved. I was shocked. It is bizarre that you trust so much on the police, and the police is filing such kind of report.
Very well, I got your point. Just have a seat. So, this is exactly what I was trying to drive home while I was speaking. Request that the law enforcement agencies or the authorities also may apply their mind and do not make a CJM or a JM feel that the non-application of mind is writ large. So there is a little bit of homework to be done, and that is why I would say that kindly put it across to your subordinates. Here the higher echelon is here, that a little understanding or application, because what she is highlighting is a complete non-application of mind, and this could have been easily avoided. And I would request the DGP to respond.
Can I, since I'm not aware, can I tell SP Pakyong to respond? I think these are two cases of Pakyong district. Are you aware of them?
No, sir. Maybe it's an old case.
May I, sir?
Yes.
So the order sheet was forwarded to SP Pakyong immediately.
When did you forward?
Immediately, lodged.
When?
Last month. Last month it was forwarded. I think Madam was there. I had given direction. It was forwarded to Madam. SP Pakyong was forwarded.
I'll look into the matter.
So, sir,
What in fact you are suggesting, in cases, for example, if you say that some accused has been arrested, and here I think you are also telling that articles were also recovered. My logical common sense would tell me that this would be also then recorded in case diaries, because in this particular date I have arrested the accused and taken a remand, and on this particular date I went and did this recovery. Then logically, unless, because once articles have been recovered, then obviously it is to connect the accused and the articles recovered. Unless there is more evidence to suggest that though articles were recovered, but after final investigation we could not connect this to the accused. Unless that is done, then what the learned magistrate is saying is perfectly correct. I do not know the intricacies of the case, because at my level these cases don't come, they finish at the district level, and the charge sheets of the final reports are sent from the district SP office straight to the courts. I think then the magistrates are well within their judicial purview to take these cases to logical conclusion, and if you think in your learned wisdom that the case is not fit for a final reporting, it can be sent back, and then you think that you have arrested an accused and you have also said that this is connected, then it should be charge sheeted. I absolutely agree with you. In this forum, let me also agree to the fact that no one is making a case here and vouching for every investigating officer that whatever every investigating officer is doing in every case is 100% correct. I think no senior police officer would even dare to do that thing. A lot of mistakes are committed and we do accept that. I think today's thing is basically on a particular issue which his lordship is also telling both the pillars of the criminal justice system, that there is a certain scare which has come due to a particular ultra-conservative interpretation of two important judgments of the Honorable Supreme Court. I think we are here today to delve into only that component, and we are absolutely cognizant of the fact, and we have taken this home, and I assure this house that when I go back, I will also do a refresher course with our investigating officers, where the checklist also will be now slowly supported with a lot of evidence on basis of which you are coming before the learned magistrate in a particular way. That is point well taken. And secondly, in case we find that the accused is an honorable person and it's quite okay to serve him a 41A notice and he is going to appear before us and he will comply with all the legal mandatory provisions, then we may even decide not to arrest, because it is, as his lordship is saying, that it's not a mechanical thing that you have to just arrest. We are only talking certain cases, as I mentioned, especially thefts and burglaries, loitering cases, naturally 7 years and above, but again with a lot of evidence before the magistrate. In many of the cases where a lot of cyber crime is occurring, because the moment you get to know of a person and you give him a notice and say come after 3 days, means that person is surely absconding. He is never going to come back. I just needed to inform very informally in a particular case, not knowing, telling the name, which everybody can understand. We have spent almost 4.5 lakhs of rupees, and the reason being because we were serving notices knowing that that person is never going to come. He took advantage of the notice, and that is how, where he went throughout the country running from place A, and the police followed suit. Today I think, isn't it a great criminal waste of money? And that is because of a misinterpretive understanding of a particular judgment. And I think, sir, today you have really cleared, and all the honorable resource persons, I thank you from the bottom of my heart, because you have also given us a lot of insightful ways. And I am sure the police officers now understand, and we will train our investigating officers on that. We will certainly train. And madam, I think in those particular cases, if you feel that those cases are not fit for final report, please send it back to the district SP saying that charge sheet, because there is evidence. In fact, we are on the same page. Justice has to be done. How can accused, if he is caught stealing and the articles are also be connected to him, why should it be final reported? He should face a trial before them. We entirely agree. Thank you.
Thank you, Mr. Sachdeva. Before we close today's program and session, let me have the last word to tell you something, both sides. DGP just referred to some honorable person, and immediately I thought Shakespeare is the best way to say, yet Brutus was an honorable man and so they were all honorable men. This is a quote from the Marcus Antonius speech in Julius Caesar. What I want to say is, apart from Shakespeare, is honorable is not a feather in the cap, it is the conduct. So there would be people who would be running away from law, and there would be people who would be able to come forward and say, I am ready to face justice. So there are two categories of individuals we are looking at. One who knows that he or she is innocent, so he or she is ready to come before any law enforcement authority or any court and sort of establish his or her innocence. They have to be treated differently. And there are people who are habitually, compulsively running away from law. So, in judicial interpretation, I would say their bona fides are suspect. They cannot be treated with the same manner in which those who are not running away from law. So the learned judiciary, members of the judiciary should take note of this, that when the police presents you with a factual note of someone who is habitually running away from law and someone who is, to borrow Benoy having high blood pressure. In fact, there is a judgment of the Honorable Supreme Court of the 1990s or 80s in a customs matter, which actually says that there are a certain kind of people who keep going to the hospital whenever this kind of matters are. There is a judgment. I can give it to you. It's all in my khata in Calcutta. I'll give you. There is a judgment of the Supreme Court on that. People nowadays don't, and these are not on online because these are pre-online days. So there is a judgment which says that those wealthy and privileged few who are in these white-collar crimes like customs. This was the customs or central excise matter. So they keep running to the hospital the moment they are served a notice. So exactly what you are saying. So these are where the bona fides become suspect ab initio. And there are people who would not run away. Those people should be looked at differently, and those people who keep running away, just don't favor them just because there is a technical glitch made by the IO in some manner. Look at it holistically. With these words, thank you very much.